14A District Court for County of Washington, State of Michigan is now in session. All those having been for the court draw near, the Honorable Judge J. Cedric Simpson preside.
You may be seated. Ms. Lundy.
Good morning, Your Honor. I have Lonnie for the people. At this time, we will waive any conflict in this honorable court in the office. And we do not believe that any conflict exists, and make waiver for the avoidance of all doubts.
Thank you. Mr. Brown.
She said that fast.
Good morning. That's called efficient. Let's see what you do. No, go ahead.
Good morning, Your Honor. Warren Brown, Deputy Chief Public Defender. We likewise do not believe that any conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflict.
Thank you, Mr. Brown. That was efficient. The court for its part also does not believe the conflict exists either in Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Robert Heft.
Good morning, Your Honor. Amy Reiser, appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Heft. Mr. Heft, can you state your name for the record?
All right, we are getting him right now. He might not be able to do it. Hey, Robert, I got you for a thing real quick. Yeah. I don't think this was.
Is that Mr. Heft?
Yep.
All right, defendant is present. Go ahead.
Your Honor, I received a report stating that Mr. Heft was incompetent and not restorable within the time frame. I would stipulate to the court and did prepare an order to the court for signature regarding that.
And will not and is not restorable.
It's not restorable.
All right. Any response from the people?
No, Your Honor, I am not able to get into the county system this morning, but I would not dispute Ms. Apple's representation.
That is what the report reads. The defendant is found incompetent. How are the people going to proceed?
So there's an option on there that we file a petition, and so I need to review the file to see if we will file a petition for commitment.
All right. So what I will do is I
think check it and we'll get it filed.
all right. Well, the question is whether I set a new date so that we review it. Otherwise, it's going to sit there if something falls to the cracks. So why don't I, how long will that take you think?
Excuse me?
Yes.
Hi, sorry, I work here in the court office where Mr. Heft is hospitalized. I just want to let you know, we have already completed the petition and certs to probate him. So it's already been completed with Washtenaw Probate Court.
Oh, fantastic.
Then my office won't file a petition. Thank you.
All right, then what I'm going to do is I'm just going to find him incompetent and continue, and you'll have to at some point send a nollie process.
Yes.
No, I suggest you go back to school there, Judge. I'm not incompetent.
Okay. Thank you.
The letter, or do you?
I'll do that this summer. All right. Thank you, Mr. Heft. Court does call the case of the people versus Andrew Cooper.
And good morning, Your Honor. Uwe Daus on behalf of Mr. Cooper in both files. There.
Do we have it?
He's at MDOC. He must have stepped out. He's right there. Yeah.
Mr. Cooper.
See him listed, but not in the room.
There? Yeah. My label is just covering that. Mr. Cooper. Okay, so it's going to be that kind of day.
That's okay. I'll take a seat.
Huh? Okay, I'll pass it.
Thank you.
You see him wake up. Let me know. Court does call the case, people versus Stephanie Woodall.
Andrew Childers appearing on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Woodall, who is present via Zoom from the MDOC. Ma'am, can you please unmute and state your name for the court?
Stephanie Joy Woodall.
Thank you.
Thank you, Your Honor. I'm respectfully requesting an adjournment. The people did extend an offer this morning, which I was able to convey and discuss with Ms. Woodall, but we just need a brief adjournment to get that written up for the court.
That is what. Probable cause conference will be adjourned February 13th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you. What else?
Thank you, Ms. Woodall.
Thank you very much.
Court does call the case, People versus Sean Burrow.
That's a lot of people.
You have a wad? I have a early.
Would you call, Your Honor? I'm so sorry.
Mr. Burrow.
Mr. Mawan's case.
Has he filed a substitution?
I don't clear out the house in this morning.
Is he intending on joining us?
He wasn't here early.
Sorry, Judge.
It's okay. Everybody was pleased with waiting.
Well, if you're gonna send me away to the jail, you remember my cousin Vinny? He went in the school bus. I want the school bus.
Okay. All right.
Elias Muad appearing on behalf of Mr. Burrow.
People are gonna be nollying this case, so that
Oh.
will be overturned.
All right.
Better not object.
Then I will. I assume there's no objection.
No objection.
All right. So this case is dismissed and I'll sign the order when it comes in. Mr. Burrow, he almost blew it. I'm just saying. All right. Thank you.
Thank you, Judge.
Appreciate it.
Court does call the case, People versus Dion Baldwin. I think what's his name?
Edward Drukas on behalf of Deanne Baldwin. Good morning, Your Honor. Edward Drukas on behalf of Deanne Baldwin.
Your name, sir?
Deanne Baldwin.
Thank you.
Today is a day for PTC. I'm asking for an adjournment. I need to obtain the video in each case.
And that's already been requested on its way, I'm assuming.
What's that?
It's been requested and it's on its way to you.
Yeah.
Okay. Probable cause conference February 20th.
I'm asking for a PR bond.
Regarding the adjourn date, I'd ask for the soonest date. Is that the earliest date?
2/13.
Understand that we want to address bond.
25, 9 a.m. I'm assuming you want to address bond.
We would like to address bond at this
Okay.
time. Regarding bond, right now, I believe he's at a reduction on the bond. He's not able to pay it. He's looking to test it corrections.
Response.
Eligible for a PR bond. He was out on bond in one of the two files, did not appear before Your Honor, bench warranted, well in absconder status with that bench warrant out for his arrest. He picked up the new case and now he's back in custody. So he's not eligible for a PR bond.
With that being the case, I'd ask for the soonest available date.
2/13/2025, 9 a.m. bond. Motion for bond reduction denied. Bond will continue.
I want to pay the bond then today. I have the money.
You can pay the bond.
Okay, so we're gonna pay the bond. We're gonna pay the bond this afternoon.
Sounds good.
All right.
You know, if you have to bring a Bill's bond.
Thank you. I think did he wake up? No. He is. Mr. Krupar? Mr. Krupar? He was up. I doubt some. And I guess not so much now. Mr. Krupar? No, he just moved. Are we sure he can hear me?
We are not. I did email the facility.
Okay. You did email him.
Yes, sir.
Court does call the case of the People versus Samantha Cosley. Cosley.
Ready, all right.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Ms. Clausick, who stands to my right. Ms. Clausick, if you could state your name for the record, please.
Samantha Nicole Fosdick.
Thank you very much. And Your Honor, at this time, we have executed paperwork, and I've advised my client regarding her rights moving forward. She would elect to waive preliminary examination and proceed to circuit court.
This is a operating while intoxicated causing serious injury.
That's correct, Judge.
And does she have a medical marijuana card?
Your Honor, she has an expired one and she has an application.
And why is she using?
Your Honor, we don't.
Mr. Allen.
I would not advise her to comment on that. But Your Honor, she does have a doctor who has certified, who has executed the appropriate paperwork, which is sent to the state. We believe that card is in the mail.
I didn't hear the court's, I'm so sorry.
When was that done?
That was done immediately after she exited Maple Grove, Judge.
Immediately after what?
She exited the inpatient facility where she was in between the last hearing and today. So we do have some documentation, Your Honor, from the doctor's office.
When did she get out of the facility?
I have precise dates in my phone.
I went in on the 6th.
Yes, I believe it was the 22nd. Well, her appointment with Dr. Durinka was January the 22nd, Your Honor. So at that point, she was out of the facility.
When did she go in?
The 6th.
The 6th of January.
Came out the 22nd.
Your Honor, it was close to, without going back to my file, I don't want.
That's fine.
Okay.
But, and then is using.
With Dr. Cert, I understand, Your Honor. I mean, I'm not going to dispute the drug test.
Counsel approach.
Yes, Your Honor. Once we get these results, we're.
You may want to mute. Yeah,
Yep.
if you were.
Just wanna record. At that point, we're gonna get. Nature of this challenge, the fact that she doesn't have the ability to use that kind of just can't happen. And they're wondering if inpatient works, if you get out and use it. All right, so we're gonna assume that if we can get those today, we're trying to know how today to get it back. Otherwise, we're gonna do it very sugar chip. Thank you, Your Honor.
All right.
Your Honor, I appreciate the bench conference in this matter. At this point, while we have a lot of what I would call circumstantial evidence of what we've already said, that there's been an application made, we believe it's going to produce a card. We understand Your Honor's position that right now, technically, we're in a legal gap there. And we understand the results of the test. We do not dispute the results of the test. I would ask for the shortest possible adjournment. Ms. Klossick was being tested while in the Maple Grove facility. We're going to get those test results and forward them to Your Honor as soon as possible. For now,
Once I get those, I will reconsider the decision I'm about to make now. But given the nature of the charge in this case, with operating while intoxicated causing serious injury, she's using, prior to her going into treatment, there's cocaine and 2 other drugs in her system, comes out of treatment. And now I still have another drug in her system that cannot be tolerated and won't be by this court. So at this point, I will adjourn the probable cause conference to February 6, 2025 at 9 a.m. At this point, defendant's bond is revoked. Defendant's remanded.
And Your Honor, one more point. I do have a letter from her medical doctor regarding her future testing, stating the basis for a recommendation of swab testing. I can provide that to both Sister Counsel and Your Honor for when eventually she is released, and we're gonna.
Well, if you hold on to that, then I'll certainly address it next week.
I'll send this with the test results, Judge, to all parties.
That'll work.
Thank you, Your Honor.
All right, thank you. Court calls the case of the People versus Russell Axelby.
Echelon for the people.
Ready, Your Honor.
And once again, good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Axelby, who's now standing to my right. Mr. Axelby, if you could state your name for the record, please.
Russell Axelby.
All right. I have before me a plea form. Is that what we're doing?
That is correct, Your Honor.
Plea form indicates that defendant will be pleading. It doesn't say what type of plea.
Your Honor, the plea is an added count 3.
No.
That's guilty.
Oh, he's going to be pleading guilty in this.
Thank you. So he's pleading guilty to an added count, well, the charged count 2, as well as an added count 3 of operating while intoxicated, second to 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed.
That's correct, Your Honor, along with the Killebrew requiring a sentencing into the 14A sobriety court program.
Yes, indicating that he must enter into and complete 14A sobriety court.
That is a correct and complete recitation of the plea agreement, Your Honor. As the court knows, count 2 does require mandatory forfeiture of the weapon.
Yes.
We understand that as well, Your Honor. We also agree that that's a complete recitation of the agreement in this case.
May I have an sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Russell Axelby.
Has he signed any advice for us?
Your Honor, I believe that was executed actually months ago in this case.
I don't have one.
You don't have one? Sign there. Date right here. Thank you, Court. Thank you, Judge.
So Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor offenses. Is that correct?
Correct.
First offense is the stated count 2 on the complaint, which is the charge of possession of firearms under the influence. That's a misdemeanor punishable by up to 93 days in jail, a $100 or $500 fine, depending on whether or not there was use or discharge of the firearm, and mandatory forfeiture of the device. You understand all of that?
Yes, sir.
All right. Also, it's this court's understanding that you're going to be pleading guilty to an added count 3 of operating while intoxicated second offense. That is a misdemeanor punishable by up to 1 year incarceration, a $200 to $1,000 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
Understanding all of that, and I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge in this case. You would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes, Your Honor.
All right. Now, understanding all of that, sir, do you still wish to plead guilty?
Yes, Your Honor.
To the charge of possession of a firearm under the influence, how do you plead?
Guilty.
To the charge of operating while intoxicated second offense, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Sorry?
You signed an advice of rights form today?
Yeah, yes, Your Honor. Yes.
Any question regarding any of those rights?
I don't believe so.
All right, on the podium, there's a copy of one. Please look at paragraph 5. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Right to remain silent.
Yes, Your Honor.
You understand you're giving up your right to appeal of it.
Yes, Your Honor.
Are you on probation or parole?
No, not this time.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And also because you believe that you're guilty of these charges?
Yes.
February 12th, 2024, at the location of North Ann Arbor Street near Woodland Drive in Saline Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
All right. Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes.
Do you recall what you had and how much?
3 to 4 beers.
All right. Were you stopped by the police?
Yes.
Why'd they stop you?
They pulled me over for going 5 miles an hour under the speed limit.
Mr. Exelby, do you recall why the officer stated that he pulled you over?
For slowing down and going 5 miles an hour under the speed limit.
Did Officer Belknap also allege that you accelerated to 38 miles an hour in a posted 25 zone?
I don't recall that evening, no.
Are you disputing that?
I was in the police report.
Okay. Are you disputing it at this point?
No.
All right. Are you disputing or challenging the right of the police to stop you in this case?
No.
All right. Were you ultimately arrested?
Yes.
Okay. Were you taken to the police station or hospital?
Police station.
All right. Were you given a data master breathalyzer test?
Yes.
Your Honor, I will stipulate for the purposes of this record an intoxilator result of 0.16.1, I'm sorry, 0.176 and 0.174.
And so you have no reason to dispute those test results?
No.
All right. Sir, had you previously been convicted of operating while impaired on or about April 20th, 2024 in the Chelsea District Court and or on May 1st, 2017 in the Adrian District Court?
Yes, Your Honor.
All right. And sir, did you have a firearm in your possession at that time?
Yes, I did.
All right. Where was that located?
It was unloaded and cased in the back seat of my truck.
Okay, but you did have that in your possession?
Yes.
And you acknowledge that you were under the influence of alcohol?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
We're satisfied.
Satisfied, Your Honor.
Court will accept the defendant's pleas. 2 counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report and screening and assessment is ordered at 14A4. Sentencing in this matter will be
February 11th at 9 a.m.
for Judge Freshour.
February 11th, 2025, 9 a.m. before Judge Freshour.
Your Honor, and just to clarify, the email that Mr. Heaton sent out to Sister Counsel, myself, and Your Honor indicated that the following sobriety court docket where sentencing would be appropriate would be February the 13th at 8:45. I don't know if that's in error. I do have the email from Mr.
We don't have that date, but actually what I'll do is I'll set the 11th. Bond will continue. Actually, you can check. Mr. Heaton should be down the hallway.
Okay, Your Honor, may I also address bond before we move forward?
Sure.
Mr. Heaton's email is relevant to that as well. I'm happy to approach the court with the email if you'd like to see it. May I, Your Honor?
Yeah.
Thank you so much, Your Honor. Your Honor, the email.
Had two cases and they're taking an hour.
Your Honor, in this case, we have the sentencing date listed there in the email, but we also have Mr. Heaton stating that if either Mr. Exelby's bond were reinstated or whether he was given a PR today, that sobriety court would immediately take over his supervision moving forward. That would include testing as well as administration from the specialty court, which I believe would provide Mr. Exelby tools for moving forward. We would ask for Your Honor to consider changing bond, given Mr. Heaton's statement and the fact that Mr. Heaton has already been able to evaluate Mr. Exelby while inside.
I'm not at this point going to change his bond. I understand what it says here, but I'm not going to change his bond on that. I'm going to leave that to Judge Freshour.
Understood, Your Honor.
So motion for bond reduction is denied. Thank you. I will change the date on that email to the 13th.
Okay.
At 8:45. Although we don't have that date, I do see that in writing, so I'll set that.
Thank you, Your Honor. If something's incorrect, I'm sure we can work with the people in Judge Freshour.
Yes.
Take care, Your Honor.
All right. Thank you. Court calls the case. People versus Jacqueline Jones, Washington. Thank you. Who's on it? Jones, Washington. I have her. I don't have, who's counsel?
Mr. Gaddy's right.
Oh.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender
God,
for Ms. Jones, Washington.
Washington, can you state your name, please?
Jacqueline Jones, Washington.
Thank you.
Your Honor, this is the time and date scheduled for a competency hearing. We are in receipt of the competency evaluation from the Forensic Center. I don't have anything else to present. I don't object to its admission.
All right.
I have met with Ms. Jones, Washington and discussed the matter with her.
Any response from the people?
No, Your Honor, the people do not.
All right. We find that the defendant at this time is incompetent to stand trial, but likely will obtain competence with proper treatment. Once I receive an order, I will sign that. I'll set a competency review hearing date for give me 90.
May 1st at 9 a.m.
May 1st, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case of the people versus David Furman. AG case.
I'm here.
Yes. The Attorney General, can you put your appearance on?
Yes, Your Honor, I couldn't hear anything. Yes, good morning, Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning.
Good morning, Your Honor. Edward Drucas on behalf of David Furman.
All right, what are we doing?
Your Honor, I'm asking for an adjournment. I'm looking to facilitate conversation with Ms. Williams. It's switched over to a couple different prosecutors, so.
All right.
We've been exchanging emails.
Probable cause conference, he's out. Probable cause conference, February 20th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Your Honor, while I have you, I have another matter before the court. Mr. Brian Brown.
Is he in custody? Oh, we don't usually call him that way. Where's his case? Is it? No, it's the next file. So if you just waited, we would have gotten it. But that's okay. Don't worry about it. Not a big deal. Court calls the case. People versus Tory Brown. Brooks. I have one case and then I'll call your case.
I slipped in. Edward Drucas on behalf of Tory Brooks.
What are we doing in this case?
Your Honor, this is a plea. I do have a plea form executed.
He signed it advice of rights form.
Yes, Your Honor.
I don't need to ever have the. Go ahead. All right. Plea form indicates that he's going to plead guilty to an added count of use of a controlled substance, a 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed, and that it's okay for him to seek 7411. However, I cannot bind the sentencing court to that. That's the court's full understanding. Is that correct, Mr. Drucas?
Yes, Your Honor.
May I have him sworn?
Raise your right hand. You can solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Tory Brooks.
Sir, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that?
Yes.
Understanding, and you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal over it.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
January 21st, 2024, at the location of South Harris Road and E Course, Ypsilanti Township, Washington County, State of Michigan. Did you have cocaine in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. District Court sentencing in this matter will be
27 at 10 a.m. for Judge Washington.
February 27, 2025. I'm sorry, 10 a.m. 10?
Yes.
10 a.m. before Judge Washington.
Regarding bond, if I could address that.
I can't stop you, so go for it.
Thank you, Your Honor. He is taking responsibility today. He's looking to get out. He went into custody for not following the bond conditions at community corrections. He's been in for 2 weeks. I think he has an understanding of the responsibilities he has. He's looking forward to testing again at community corrections, getting out.
Yeah, but the last time I sent him there, he didn't follow it.
He wasn't, that's correct. And that's why he was remanded for 2 weeks. With him accepting responsibility, he has the potential to lose 7411 if he's going to continue to test positive. He's facing additional jail time in the event that that were to occur. He does have 3 children that are 5, 3, and 5 months. His spouse has a broken wrist. He's looking to get back to his family, and he knows those responsibilities are much more important than failing drug tests.
Any response from the people?
No, Your Honor, counsel let me know in advance to be making this motion. I let him know as long as the plea goes through that I would leave it in the court's discretion.
All right. I'm going to deny at this point his request for a bond reduction. you can bring that before Judge Washington regarding his release, but at this time, I'm going to deny your request.
Okay.
Thank you. That means court does call the case, People versus Brian Brown. Brian Brown. Pardon? Yeah, I see that. But is he in? He's not in Zoom. I don't see him, correct? Brian Brown? Oh, he's not here, Madam Attorney General.
Good morning. I don't know if you wanted me to enter my appearance, Assistant Attorney General Clarissa
Yeah,
Williams,
go
on
ahead.
behalf of the people. On behalf of the people. Thank you.
And he's Brian Brown. He is not here. Bench warrant will issue for defendant's failure to appear. What is the amount of child support currently outstanding?
Your Honor, we have in our system $18,695.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $18,695 cash only.
Would you like us to prepare that, Your Honor?
We'll take care of it.
Okay, thank you. Have a good day.
All right, thank you. You do the same. Court does call the case, People versus Elon Bankhead.
And then on behalf of the people.
Assistant Public Defender Natalie Pate with it on behalf of Mr. Bankhead, who is approaching. Please state your name for the record, sir.
Elon Bankhead.
All right.
Thank you, Your Honor. At this time, we wish to set the case for preliminary examination. All discovery is complete to our knowledge.
All right. Where is the what?
11.
People have their witnesses available the 11th.
We'll do our best, Your Honor.
All right. Preliminary examination in person will be set February 11th, 2025, 9 a.m. before Judge Valvo. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Jack Moniz, M-O-N-I-Z.
And good morning, Your Honor.
Did I have a prosecutor stated appearance? Thank you. I'm sorry if I didn't hear you. All right.
And
Counsel,
Joshua,
state your appearance. Go ahead.
Joshua Kaplan on behalf of Mr. Moniz. Mr. Moniz, we say your name for the record.
Jack Grayson Moniz.
All right. What are we doing?
Your Honor, we're just requesting an adjournment of the PCC, waive the 21-day rule. I just got retained late last week. I have not seen the discovery.
February 13th, 2025.
And Your Honor, is there, because I'm in the bench trial that day, is there any non-Thursday mornings that you have dockets for, or just is it Thursdays?
Well, I have dockets every day, but not this.
Do you have any other state docket days?
Only Thursdays.
Okay, well, I guess then Thursday morning, I'll make it work.
All right.
Thank you.
Thank you. Fine, continue. Court does call the cases of the People versus Teresa Johnson. All three cases.
Good morning, Your Honor. Can you rise on behalf of the people?
Hey, Judge. Portia Feaster, Assistant Public Defender, appearing on behalf of Ms. Johnson. Ms. Johnson, please state your name for the record.
Teresa Johnson.
Thank you, Judge.
Again.
We did receive a notice yesterday for Ms. Johnson to resolve all three files. If we can go out 1 week, then I'm confident we can bring it to her
and close these 3 files out, Your Honor. Apology. Yeah, we have a good offer. Just need to get it to her.
No objection.
Probable cause conference, February 6, 2025, 9 a.m. Bound continued.
Thank you, Judge.
Thank you, Cedric.
Thank you.
Thank you, see you, sir.
Yes, ma'am. I'll be able to see you.
Yeah, at least he knows you by first name. No, that's good. I'll answer to most things. Court calls case, People versus Rayshawn Ellis.
Good morning, Your Honor. Assistant Public Defender Sonia Chanel on behalf of Mr. Rayshawn Ellis, who's approaching. Sir, state your name for the record.
Thank you.
Your Honor, we're asking for this matter to be set for a preliminary exam, and to my knowledge, all discovery is complete.
People have their witnesses available the 11th. Preliminary examination in person will be set February 11th, 2025, 9 a.m. before judge. Before me. Bond continued.
Thank you.
Thank you. Yeah.
That's like herself.
Okay, I got you. Court calls the case, People versus Phyllis Lindblade.
Assistant Public Defender Jay Bellinger on behalf of Ms. Lindblade, who appears via Zoom, Your Honor.
Ma'am, can you state your name, please?
Oh, I am Radhika Timofeychuk. I am the manager at Jenny's Manor for Phyllis Lindblade. This is Phyllis
There is
Lindblade.
All right, thank you.
Your Honor, my name is Yvonne Davis. I'm the guardian for Mrs. Lindblade.
Thank you.
And Your Honor, I have had an opportunity to talk to everyone involved on Ms. Lindblade's side, including Ms. Lindblade last evening. I have also made a request, given Ms. Lindblade's circumstances, for a dismissal on her matter. I am requesting 3 weeks so that I can continue my conversations with the prosecution about that.
Without objection, we will adjourn the probable cause conference February 20th, 2025, 9 a.m.
Thank you.
Thank you. Bond continued. Thank you, folks.
Thank you.
Mr. Krupar, can you hear us,
Yes,
sir?
sir.
Oh, okay,
Yes.
now you can hear us. All right. Court does recall the cases of the People versus Andrew Krupar.
Uwe Dals on behalf of Mr. Cooper on both files. Thank you for recalling it.
All right. You're requesting an adjournment?
Yes, please, on both files for discovery on each. There's not much on the file ending in 1221, only one item essentially, but on the other one, I think I expect a large number of items still to come in discovery.
He's not close to being let out or anything at this point.
No, minimum term 28 months, and he's maybe 2 or 3 months into that.
All right. Probable cause conference, I'll adjourn to February 20th, 2025. 9 a.m.
We had one item of housekeeping. I think on the file 1221, Mr. Cooper had been referred to community corrections. We keep getting reminders that he's not in compliance with that. We wonder if that referral could be removed, given his present term.
Okay, I don't know why they're sending reminders. That's not our process, but I mean, nothing's going to happen, the standard condition, because they don't know if he's going to be released. So it's in there, but you'll have to deal with community corrections, let them know where he is.
I think we did that. Yeah.
Bond will continue.
Very good. Thank you.
Thank you. Court calls case People versus Donald Foreman.
And then on behalf of the school.
Assistant Public Defender Jay Bellinger on behalf of Mr. Foreman, who approaches, Your Honor.
Your name, sir?
Donald Foreman.
Thank you.
And Your Honor, to the best of my knowledge, discovery is complete. Request a preliminary examination.
Do other witnesses available to the 11th? Okay, to 11, okay. Preliminary examination will be in person. February 11th, 2025, 9 a.m. before Judge Valvo. Bond will continue. Thank you.
I'm for witness.
Court calls case People versus Ernesto. Zuniga Alvarez.
Jacob Kennedy for behalf of the people on the 0065.
And Absalani for the people in the matter.
Assistant Public Defender Chelsea Vergils with and on behalf of Ernesto Zuniga Alvarez. Mr. Zuniga Alvarez, please state your name.
State your name.
Ernesto Zuniga Alvarez.
We're asking for an adjournment. One of these cases is relatively new and we don't have video discovery on that yet.
Hearing it to the 13th. Probable cause conference February 13th, 2025, 9 a.m. Bond will continue in these matters.
Thank you.
Calls case of the People versus Cedric Green.
Andrew Childers appearing on behalf of the people, Your Honor.
Ron Brown appearing on behalf of Mr. Green, Your Honor. Good morning.
Good morning, sir. Your name, sir?
Cedric Green. Thank you. Please set exams for all matters.
All discovery is complete.
Yes, Your Honor.
Would the people have all of their witnesses available on the 11th?
That's fine, Your Honor.
Yeah.
Preliminary examination in person will be set February 11th, 2025, 9 a.m. before Judge Valvo. Bound continue. Thank you. Here. Court calls the case of the People versus Robert Boggs.
Judge, Portia, Assistant Public Defender, on behalf of Mr. Robert Paul, who is approaching the podium. Mr. Boggs, please come forward and state your name. Please come forward and state your name for the record.
Robert Boggs.
Thanks.
Thank you, Judge. I have spoken to Ms. Landy on this matter. Mr. Boggs is hoping to get a reduction on this file. I need to come up with some information that might move Ms. Landy to be inclined to do so.
You have to come up with the information that's going to move Landy.
That's my goal, Judge. That's my goal.
God bless you. All right, so
we could do 3 or 4 weeks, please, Judge.
3 or 4 weeks. Will the 20th work?
That's fine, Judge.
All right. Probable cause conference February 20th, 2025, 9 a.m. Bond will continue.
Thank you.
All
Thank
right.
you, Judge.
Thank you.
Thank you, Your Honor.
You're welcome.
Got my number.
Yes, I got
Right.
plenty of
Okay.
people fighting for
Okay.
me.
All right. 2:20. See you then.
Thank you, Your Honor.
Yes, sir.
Court does call the case of the People versus Jacob Halfacre. CM. Okay. Go ahead.
Assistant Public Defender Asli Bashir here with and on behalf of Mr. Jacob Hackney.
Your name, sir?
Jacob Hackney.
All right. I have the report. Date and time set for a competency hearing.
We would stipulate to the report.
All right. Any additional information from the people? All right. Court will find that the defendant is incompetent to stand trial, but likely to obtain competence given treatment. I will sign that order and I will set a competency review date for May 1st, 2025, 9 a.m. Fine, we'll continue. Thank you.
In the honor, do I have a $10,000 bond still?
What do you have as bond? That's what I am seeing unless something. Yes, sir. Yes, sir. Thank you. Court calls the case People versus Letitia Brock.
Andrew Childers appearing on behalf of the people.
Brock?
Yes.
Okay. We need her attorney. I think that's Miss Cannon. I realized last Thursday was rough, but she needs to appear today.
I apologize, Judge. I can stand in if there's something resolved.
Mr. Childers is in Zoom, so
Oh.
it's hard to have that conversation. Is Miss Cannon
Miss-
here?
Yes, Judge, I apologize. She's in the block.
Does she want to stay?
You need me.
Right? Why are you come? Did I say yes?
Oh,
did I?
May I approach? This for
You're up here now. Just why did you just hold on? Just stop.
Go off for me.
Good morning, Judge.
I didn't even say yes. He all up in my face. All right, ma'am. I'm gonna wait for your. She's back in lockup talking to another client, so I'm gonna pass your matter briefly, and we'll get you called up momentarily. Okay?
Thank you.
Thank you. Oh, now she's here.
I'm sorry, Your Honor.
No, perfect timing. No, no need to apologize. So why are you going over there?
Ms. Brock, yes, Your Honor, thank you. Stephanie Cannon appearing on behalf of Ms. Brock.
All right, Ms. Brock, can you state your name, please?
Lastasia Brock.
Thank you.
Thank you, Your Honor.
You need to thank Mr. Brown for Mr. Brown. Mr. Brown covered for you. He was all up here at the bench. He was buying you all kinds of time.
Thank
But
you,
go
I
ahead.
appreciate that. Your Honor, a lot has happened on this case. The OWI second that the court was waiting to be filed, I believe, was authorized on the 28th. So that charge has now come to light. My client is wanting to wait to see if she can get a global resolution on this case. I did email Mr. Childer. She's doing exceptionally well currently on probation. I believe that this case is resolvable short of trial, but she wants to waive over.
To circuit. All right.
Yes.
Ma'am, is that correct?
Yes.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right?
Yes, Your Honor.
All right.
Oop, sorry.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1, 2, with 3 following.
Your Honor, my client would waive formal reading and stand mute as to the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea to all 3 counts. Pretrial in this matter will be set for March 31st, 2025, 1:30 before Judge Hamud.
Thank
March
you, Your Honor.
31st,
I'm sorry?
March
Yes.
31st.
Yes, March 31st.
Okay, thank you,
Great.
Your Honor.
A great day.
You too.
Yeah, bond continue.
Next time for Mr. Childers.
Yeah, continue. Court calls the case of the people versus Jalecia Harris.
Assistant Public Defender Jay Ballinger on behalf of Ms. Harris, who approaches. Ms. Harris, can you please state your name for the record?
Thank
Your Honor, my understanding is that my client will be entering a plea today. I can let.
Sure. Your Honor, that is correct. The defendant will be pleading to currently charged count 2, retail fraud, second degree to 1 year with $2,000. $2,000 fine and trouble amount, and count 1, possession of controlled substance will be dismissed. The defendant will have to enter into mental health treatment court as a condition of this plea. I understand she's already been accepted and they're ready to start supervising her, I believe.
My understanding is that she was entered into that court on the 15th of January, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
State your name.
Jalecia Harris.
It is this court's understanding you're going to plead guilty to the charge of retail fraud in the 2nd degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yeah.
All right. Understanding all of that, you still, well, I also have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. Understand that?
Yeah.
All right. So wish to plead guilty?
Yeah.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind? Yes?
Yes.
All right. You signed an advice of rights form?
Yeah.
I signed it on her behalf, Your Honor.
All right. You read the form, ma'am?
I read that to you, correct? And it's stated
All right.
here. Okay.
Any questions regarding any of the rights on that form?
You have to say it.
No, no.
All right. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And also because you believe that you're guilty?
Yes.
November 4th, 2024, at the location of 231 South State Street in the city of Ann Arbor, Washtenaw County, state of Michigan. What'd you do at the Target store that makes you think that you're guilty?
I stole items.
You stole items? So you went into the store and tried to walk out without paying for them?
Yes.
Yes?
Yes.
All right. The store was open to the public at the time?
Yes.
You didn't have anybody's permission to take that property, did you?
No.
And this property that you took was property that was offered for sale by Target?
Yes.
All right. And was the total amount of the property, its aggregate or the total amount, was that in excess of $200? The value of it?
Yes.
Yes? All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
February 14th at 10 a.m. for Judge Perry.
February 14, 2025, 10 a.m. before Judge Perry.
Your Honor, if I may, Esteban, I'll be brief.
Probably not, but go ahead.
My understanding that of the situation is that Miss Harris came back into custody after she went to court on the 23rd. She was arrested for missing court. She was in treatment at Spera at the time. She did, however, start outpatient treatment with them, but that had to stop because she came back into custody. My understanding is that she has a remand from of $1,000 out of the 15th District Court. She also has a 25,000, 10% bond out of this court. She is asking for a PR bond out of this court. She advises that she can stay at her apartment, which is located in Ann Arbor. I believe there was an email that I read earlier this week. The court advised that the warrant would not be set aside until she came back to court. Your Honor, she's willing to do home confinement GPS tether. I understand that she still needs to go before the 15th district. However, I wanted to see if I might be able to get a PR for her on this case.
When is she to go?
Her next court date for that court is set for the 30th. Well, today it looks like on the retail fraud.
On the other retail fraud?
I believe so, yeah. Both cases are set for today.
Okay. Response from the people.
And I'll leave it to your discretion. I think that just the concern here is just keeping the consistency of treatment.
Right. Well, if she's got to go, and she's held currently on the 15th District Court one.
It appears so, Your Honor, with a $1,000 bond.
So what I will do is in this matter, given the plea, the charge, I will set the defendant's bond at a $5,000 personal recognizance bond, with her conditions remain in effect. All right. And then if they want her held, they can hold her on the other case.
Understood.
Everything's going over to 15th anyway.
Okay, thank you very much.
Thank you.
It's okay, you still have to answer the 15th. You still have a $1,000 bond there, okay? All right. All your conditions are in effect.
Court calls the case, people of the state of Michigan versus Amy Bullens.
Andrew Childers appearing. Andrew Childers appearing on behalf of the people.
Assistant Public Defender Chelsea Vergil is with and on behalf of Amy Bullens. Miss Bullens, please state your name.
Amy Ruth Bullens.
Thank you.
Gunnar, we're asking for a short adjournment. There's been an offer I'd like to discuss with my client further.
All right. Probable cause conference, I'll adjourn that to February 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Joel Helm Mormon.
Actually, one of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Helm Mormon, who's approaching now. You state your name for the record. Thank you. Your Honor, there's some outstanding video discovery. We'd ask for an adjournment.
That objection, probable cause conference will be adjourned February 13th, 2025, 9 a.m.
Thank you, Your Honor.
Court calls the case people versus Amy Burberry.
Andrew Childers appearing on behalf of the people.
Public Defender Fellow Nicholas Bukovich on behalf of Ms. Burberry, who's standing to my right. You can state your name for the record.
Amy Burberry.
Okay.
Your Honor, I'll be requesting a brief adjournment at this time to obtain media discovery.
Probable cause conference will be adjourned February 20th, 2025, 9 a.m. Bond continued. Court calls the cases of the people versus Aaron Malcolm. Or McCollum, I'm sorry.
Actually, one of the people.
Pardon? They're PD cases without an assignment. Gotcha. Yeah, they weren't assigned. Your name, sir?
My name is Aaron.
Gotcha.
Aaron McCollum.
Thank you.
How you doing, sir? Torshell Feaster, Assistant Public Defender, standing in on behalf of Mr. McCullum.
Let me just say, and we didn't have a PD assigned to this. I don't know how much you know about this. I'm going to adjourn it out 1 week.
Thank
you. Review. There was a forensic report that came in on the 8th, finding him incompetent,
Oh, okay.
but likely restorable.
Okay, awesome.
I'll adjourn it out of.
Thank you very much, Judge.
Look at that. I'll adjourn this matter to February 6th. Both these matters, February 6th, 2025, 9 a.m. Bond will continue.
Thank you, Judge. All right, man.
Court calls the case People versus Kevin Burden.
Stephanie Cannon, on behalf of Mr. Burden, who's appearing to my right. Mr. Burden, could you please state your name for the record?
Kevin Burton, you're on.
Thank you.
Your Honor, we are in negotiations with the prosecutor's office on this case. We are asking for a 2-week adjournment of the matter.
Without objection, probable cause conference will be adjourned February 20th, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Oh. That brought joy to my heart. Court calls the case People versus Joseph Pinkston.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Pinkston, who is approaching the podium. Please state your name for the record, sir.
Joseph Pinkston.
Thank you, Your Honor. I have been able to discuss both cases, both with my client as well as with the people. We are discussing a potential global resolution of both matters. We're requesting a 2-week adjournment for further discussions.
Without objection, probable cause February 13th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Cameron Carey.
Portia Feaster, Assistant Public Defender on behalf of Cameron Carey. Please take your name for the record, sir.
Cameron Carey.
Thank you, Judge. My understanding is that we are seeking a preliminary examination on this file and that our discovery has been completed.
Do either witnesses available the 11th? Preliminary examination in person, February 11th, 2025, 9 a.m. That is before me. Bond will continue. Court calls the case of the People versus Thomas Rastel. Your name, sir?
Thomas Rastel.
Smith Cannon.
Stephanie Cannon, we have Mr. Rastel. Mr. Rastel, could you please state your name for the record?
Thomas Eugene Rastel.
You want to waive up, right?
Yes.
Your Honor, my client is going to waive to circuit court on this matter.
Is that correct, sir?
Yes, it is.
All right. You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
I do.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir. Yeah, yes, Your Honor.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following.
Thank you, Your Honor. My client would waive formal reading and he would stand mute as to charges.
Defendant every way formal reading standing mute as to both counts. Court will enter a not guilty plea. Pretrial will be set for
February 6th at 1:30.
February 6, 2025, 1:30, Judge Slay.
Your Honor, can I address bond?
You may.
Your Honor, when we were in court the last time, I did talk to the court. I confirmed that if the client is, if my client is not released, he is going to lose his home, Your Honor. We're just simply asking that he be released in on GPS tethered to his house, Your Honor. We are hoping to negotiate down, way down. I understand that he has some holds. Our office is working with Lansing and Battle Creek to see if we can get him arraigned on those. So the question just simply becomes, once he's arraigned on those charges, will the court entertain releasing him on GPS tether? It's my understanding that those holds are very old,
10 and 15.
10 and 15 years old. And we're, like I said, we're trying to get him arraigned on those so that he can take care of those matters. And my client is not opposed to GPS tether, Your Honor, but his housing worker has said if he is not released, even if we can get him furloughed out for a day and bring him back, he's going to lose his housing.
Is it housing commission property?
Yes, Your Honor.
Did they say why they were gonna do that?
Give me one
It's
second.
not typically what they do.
This is, it could be because he also has a lot of cats at the house. Which it's my understanding, 2 cats at the house which aren't being cared for.
But if I release him on this, he won't be released. He's gonna go to Battle Creek.
Your Honor, and again, we're trying to work that out, but it's my understanding that they never actually came and got him. So no matter what, like the last point of contact that he believes that they are not going to come and get him because they never have. And what happened here is he was in prison for the majority of that, which is the reason why he was not picked up on it in the first place. And then once he was released from prison, they never sought to come and get him as it relates to those charges.
Any response from the people?
No, Your Honor.
And it's the A2 Housing Commission. They actually got in
Yeah,
touch
Ann
with
Arbor
us.
Housing. Okay, go
I
ahead.
know the
What?
court's very familiar with,
The house. Yeah.
and housing commissions in this county.
When did they say he would lose his housing?
When they called, they said, they didn't give us a date, Your Honor. When we spoke to them, they said that he is at risk of losing his housing. I can call and confirm the date and let the court know. Would that be sufficient?
I certainly would look at it, but you're gonna have to get it done today because otherwise it's gonna go up to Judge Slay to make a determination.
Okay, Your Honor.
But I'd like to know why they would be doing that and at what point does this housing become in jeopardy? Is it before the February 6th date? Because otherwise this can be brought before Judge Slay. But if you let me know today, then I'll do that and strongly consider releasing him on a PR. But my concern is that if I release him on a PR, he may go someplace else, which isn't gonna solve his housing issue.
I will, our office will work on that now, Your Honor.
So at this point, I will deny it. And if you get that information to me, I'll take a look at it. Okay, Mr. Russell, I'll take a look. Okay,
Thank you, Your Honor.
thank you.
I will. May I approach or this is waiver form?
Court calls the case of People versus London Dottery.
Ready again, Judge.
Andrew Childers appearing. Sorry, Andrew Childers appearing on behalf of People.
Torshall Feaster, Assistant Public Defender on behalf of Mr. Dottery. Mr. Dottery, please state your name for the record.
London Dottery.
Thank you.
Thank you, Judge. Mr. Dottery has these 2 files. He would like me to try to seek a better resolution than what is currently being offered.
You what?
He would like me to seek a different resolution than what is currently being offered. I believe these are
So he
both.
wants you to do better?
He does, Judge. He
Oh,
wants me to be
okay.
better, do better. I will do all I can for him, Judge.
I know you will.
So if we could have an adjournment so that I can do to negotiate with the people, I'm hopeful we can find a satisfactory offer from Mr. Docket.
How many weeks?
Let's go 3 if the court doesn't mind, please.
3?
Please.
Can take you that much?
Maybe longer, but start with 3, please.
Oh, God, conference without objection. I'll adjourn it to February 20th, 2025, 9 a.m. All right, fine, continue. Thank you, sir.
All right, 20, so call me next week. And we'll start working on that.
I will.
Thank you. Yes, sir.
I'm not saying anything.
Thank you.
Court calls case People versus Antoine Reed.
And then on behalf of the people,
Cases.
Assistant Public Defender Asa Bashir, here with and on behalf of Mr. Antoine Reed. Sorry about that.
Reed, can you state your name, please?
Antoine Reed.
Thank you.
All right, and we are seeking to set for exam in this case.
Pardon?
We're seeking to hold a preliminary exam,
Is all discovery complete?
to our knowledge.
People have their witnesses available the 11th.
we'll do our best, Your Honor.
Preliminary examination will be set February 11th, 2025, 9 a.m. That is before Judge Valvo in both matters. Bond continued.
Your Honor.
Call the case of the People versus Jeremiah Driscoll.
And then on behalf of the people,
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Driscoll. Oh, you got him? Okay.
I'm sorry, Your Honor. Another emergency popped up. Mike Gaddy, Assistant Public Defender on behalf of Mr. Driscoll, Judge.
Your name, sir?
I am Jeremiah David Driscoll, Your Honor.
Thank you, sir.
You're welcome.
Your Honor, I believe we have a resolution in this matter.
Okay.
I believe that Mr. Driscoll will plead guilty to count 3. Counts 1 and 2 would be dismissed. Count 3, I believe, is a 93-day domestic violence charge.
Your Honor, the count 3 is a DV second.
Oh. I'm sorry. It's a DV second for 1 year, Joe. I have gone over his rights with Mr. Driscoll. He's not on
advice or rights.
I do have a signed advice or rights. There is a sentencing agreement to no more upfront jail time.
It's my case. I'm not necessarily agreeing to that. But
We understand that there's no cops. I have gone over his rights with him. He doesn't have any questions. There's no PDA issues. He's not on probation or parole.
And he's pleading now?
No contest. We have submitted the police report.
And I have read it.
Okay, and the reason being a potential civil liability.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name.
Jeremiah David Driscoll.
All right, you can put your hand down. Sir, it is this court's understanding that you are going to plead no contest to the charge of domestic violence second offense.
Yes, Your Honor.
That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. First thing you need to understand is that first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Still wish to plead no contest?
Yes, Your Honor.
And to that charge, how do you plead?
No contest, Your Honor.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
Oh, Your Honor.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Okay. Thank you, Your Honor.
I'm sorry, I didn't hear your response.
Oh, yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
No, Your Honor.
Anybody threaten you or coerce
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2558. Any objection to the court having reviewed that report?
Not from the people, Your Honor.
No, none from defense, Judge.
And you stipulate to the prior?
Yes, Judge.
All right, very good. Based upon a review of the report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's plea of no contest. 2 count 3 counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be March 3rd, 2025, 1 p.m. before me.
Thank you.
Bond will continue with its conditions in this matter. All right,
Thank
sir, on your way out on the left-hand side, you might want to stop in with probation, check in, get your appointment, start the process. All right,
Okay.
right down the hallway. Thank you, sir.
Thank you, Your Honor.
I give
Court calls the case, People versus Cadena South.
Mike Dick.
Thank you. Assistant Public Defender Sonia Chanel on behalf of Ms. Self, who's approaching. Ma'am, state your full name for the record.
Self.
Your Honor, we're asking for this matter to be set for a preliminary exam. And to my knowledge, all discovery is complete.
People, other witnesses available the 11th?
We will, Your Honor, for the record, catering.
Preliminary examination will be set in person, February 11th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you.
Court does call the case, People versus Shania Driver.
Andrew Childers appearing on behalf of the people.
Ron Brown appearing on behalf of Mr. Driver, Your Honor.
You're requesting an adjournment.
Yes, Your Honor.
Cause conference, February 20th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Court does call the case, People versus, they're not ready yet. Court calls the case of the People versus Joseph Hamby. Miss Akinruli, are you doing anything today? I just thought I'd ask. I mean, I see everybody else is, I mean, you might be doing something like that behind the scenes. I'm just checking.
She's support. She's here for moral support.
Is that what that is?
I'm good. How are you? Good to see you again.
Used to be at 12:30.
Oh, I mean, I wasn't asking. I wasn't begging for your appearance. I was just, oh, darn. Okay.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Hamby. Will you state your name for the record?
Joseph Hamby.
Thank you. There is some outstanding video on this case as well. We'd ask for an adjournment.
Probable cause conference, I will adjourn February 20th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Thank you, sir. It's done right. Court does. Oh, who's this? He's there, but. Okay. Who? Court calls the case of the People versus Theophilus Smith. Where'd that one come on?
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Chelsea Virgil is with and on behalf of Theophilus Smith. Mr. Smith, please state your name.
Yeah, listen. Thank you. What are we doing?
Your Honor, we submitted an order to the court. We're asking for a competency evaluation in this case.
too, so. Forensic evaluation is hereby ordered. Competency hearing will be set May 1st, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Muriel Hearn.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Asli Bashir with and on behalf of Memorial Hearn.
Mario Hearn. Thank you. You're requesting an adjournment.
Yes, for further negotiation.
We'll adjourn this matter. Probable cause conference will be set February 20th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Okay.
Oh, sorry. Actually, no, Your Honor. Actually, if I could address bond.
Sure.
Thank you. Specifically, the condition of travel limitation on Mr. Hearn's bond. Mr. Hearn is a photographer and videographer. He runs his own business and he travels to different states for that business. Mr. Hearn has been appearing at his court dates. He has no failures to appear in his case. He is not a flight risk. He doesn't have any kind of adult criminal history, significant criminal history.
Well, I'm not going to give him unfettered travel. So if he has a job, if the job is set up, that information provided to the court, I don't see a reason why we wouldn't provide travel. But I'm not going to change the condition. He would just, once he gets the job, have to let you know and then send over the appropriate paperwork to us.
Okay. And just for a little more context, Mr. Hearn, he has multiple jobs. So for each job, he'll need to just kind of submit.
Pardon?
So he has he works kind of on a
Or if he knows in advance of
like a list of them.
Yeah, that of where he's going and proof that that's what he's doing. I'm not going to have a problem with that. I suggest that he do that. You get that to you provide it to the prosecutor, and I don't think we're going to have an issue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Cynthia Solomon.
Amy Reisner on behalf of the people.
Ron Brown appearing on behalf of Ms. Solomon, Your Honor. Please introduce yourself.
Cynthia Solomon.
All right. You're requesting an adjournment.
Yes, Your Honor.
Probable cause conference will be adjourned February 13th, 2025, 9 a.m. Bond continue.
Thank you.
That's called the case People versus Ozell Hyman.
And on behalf of the people.
Public Defender Pavel Nicholas Bukovich on behalf of Mr. Hyman, who is approaching. Mr. Hyman, can you please state your name for the record?
Ozell Hyman.
At this time, Your Honor, we'll be requesting another adjournment to obtain a media discovery. There seemed to be an issue with it. I know APA Zenda has made supplemental requests, so this should be corrected by the next court date.
And Your Honor, in looking at the media discovery, we found out that they put the discovery for a different police report in evidence.com under his case, so it was a completely irrelevant.
To his case.
Right,
Yes.
so I requested they edit that with his police report number, and we're waiting to hear back on that.
Got it.
Was a relevant traffic stop.
Okay. And so we don't even know how much there is or what it looks like. So, okay. All right. Let's do this. Give you guys time to work that all out. I'll go to February 20th, 2025, 9 a.m. That way, if it's a lot, you'll be able to get it. All right, Bond will continue. Thank you, Mr. Hyman. Court calls the case of the People versus Darnell Taylor.
Katie Rosemont, people people.
Stephanie Cannon on behalf of Mr. Taylor, who is appearing to my right. Mr. Taylor, could you please state your name for the record?
Thank you.
Your Honor, there is no resolution in this case at this time. My client is asking for his preliminary exam.
It's all discovery complete.
To the best of my knowledge, Your Honor, yes.
People have their witnesses available on the 11th.
Dormant.
Preliminary examination will be set February 11th, 2025, 9 a.m. That is before me. Bond will continue.
Thank you.
Thank you, sir. They have them lined up in the hallway. Court does call the case of the people versus Michael Ware.
Money for the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Ware on case 25 F5 5514, Judge.
Your name, sir? Michael Ware. Thank you. What are we doing?
Your Honor, there's some video that we're trying to obtain, so I'd ask the court to adjourn this matter. I believe Mr. Goldstein has a companion matter. I don't know when that's set.
That's correct. Mr. Goldstein's matter was adjourned 1 week by stipend order.
To the 6th.
Yes, Your Honor.
You want this set for then?
Yeah. I think it might be prudent to keep them together, Judge.
February 6th, 2025, 9 a.m. Bond continue.
Okay. It was adjourned by stip. Thank you, Judge.
Thank you. Court calls the case People versus DeMarcus Washington.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Washington, who appears to my right. Mr. Washington, can you please state your name for the record?
Thank you.
Your Honor, we are currently trying to work out a resolution on this matter. I have talked to Mr. Childers about that. We'd asked to set this matter for preliminary examination at this time, and I would ask for a bond argument when appropriate.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available on the 11th.
Yes, Your Honor.
Preliminary examination in person, February 11th, 2025, 9 a.m. That is before Judge Balvo. As to bond.
Thank you, Your Honor. As to bond, my client's current bond is set for 25,000, 10%. He informs that he can stay at the Delana Center. My understanding that the bond was set so high because at the time he was out on bond for a different matter before Judge Bob. I'm sorry, it was not Judge Washington, Judge Perry. At the time, it's my understanding that when he caught these charges, that was a result of a violation on the other case. He caught a DV charge. That charge has since been dismissed. It was set for final settlement conference. It was dismissed without prejudice. I'm asking for a bond in this case, the PR.
Were the police trying to take him into custody on the violation of the other matter?
They did, Your Honor. That case has since been dismissed.
I understand that,
Yeah.
but that's what led to these charges of,
Yes, Your Honor.
of resisting and obstructing a police officer?
That's my understanding. Your Honor, my client advises he's been in custody for the last 2 weeks, that he has a job that he will lose if he's not able to leave.
I understand that, but that can't be allowed where he picks up 3 R&Os. They're just trying to take him into custody on a valid warrant, regardless of what the consequence of the charge was.
I understand, Your Honor.
I don't need a response from the people. Most for bond reductions denied. Bond will continue. Court calls the case People versus Anderson Keller.
For the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Keller.
Mr. Keller is not, he's refusing to come up.
Oh,
This is a comp review, but we don't have an order.
That's my understanding as well, Your Honor. I do think there needs to be an order from defense counsel. So there is one, fantastic, and then we can get him treated. I trust you.
Oh, thank you. Well, here's a copy for you. Yeah, Your Honor, I did run some, it looks like there was a referral back in April, then it looks like he's refused ever since. So I have a new competency order and a criminal responsibility order as well.
All right.
I can
I'll set the competency hearing date then and reorder forensic evaluation. I'll set that for May 1st. May 1st, 2025, 9 a.m. bond. This matter will continue. What do you hear? Well, this is it. When do we start back up? We're gonna do better. I can't have a gap like this. All right. I have one case left, but it's the Collier matter. But the facility wasn't signing in till 11, and we are before 11. That's all that I have left in this block. So what I'm going to do is I'm going to stand in recess. If the facility, whoever's on that case, who? So Mr. Childers or somebody else would need to be ready so that if they sign in, I'll come back out and do that. Otherwise, we're going to adjourn for an ungodly amount of time. All right, court's going to stand in recess.
All rise. Next District Court for County of Washington, State of Michigan is back in session. Judge Simpson presiding.
You may be seated. I'll wait for her to go all the way over and sit down and watch. Hold on. Miss Cannon, can you approach? Along with Miss Lundy. That was mean. I waited for you to get all the way over there and sit down before I said anything. Can you and Miss Lundy approach this?
Your Honor, thank you.
Yes.
And how's Officer White? And the word. Oh, there you are, sir. All right. Would you raise your right hand, please? Do you solemnly swear or affirm the information contained in the search warrant and affidavit is true to the best of knowledge and information you believe?
I do.
All right, fantastic. I will sign off on this and Ann will get it right back over to you.
Thank you.
Thank you. Stay safe, please. I don't know. Alan told me I'm not allowed to have any of anything. He said I just have to. If I get thirsty, so what? He said. That's how I remember the conversation. Court does call the case People versus Cynthia Lake Pier.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. David Chan on behalf of Cynthia Lake Pier.
Your name
Cynthia Lake Pier.
and you're requesting an adjournment, Mr. Chairman?
Yeah, we just got retained and obviously Andrew's operating via Zoom today, so I'd like to have an opportunity to talk to the prosecutor and see if we can maybe get this resolved.
All right, very good. Probable cause conference will be adjourned February 20th.
Well, it's fine.
February 20th, 2025. Bond will continue.
Thank you, Honor.
Thank you.
Thanks, Andrew.
Good seeing you, Mr. Chan. We haven't seen you for a while. You doing well?
I have been hanging around with horrible alcoholics and drug addicts, so I can't pick the group I hang with.
That's funny. Me too. No. All right. Take care. Why are you shaking your head, Lonnie? Court calls the case, People versus Emily Bates. Thank you, Ann.
You're welcome.
Okay, Stephanie Cannon on behalf of Ms. Bates, who's appearing by
You
Zoom.
gave their pair.
I'm sorry.
Well,
I didn't hear it, Your Honor.
What were you listening to on your way up? Okay.
Just like,
And it's
just
just gonna
like,
be one of
Your
those
Honor.
days. That's fine. I'm just glad you're here.
Just thank you, Your Honor. I appreciate it. Good to be here. Jay did it. So, Your Honor, I was just hoping to get an adjournment in this case. I have reached out to her probation officer to try and get a letter on her behalf regarding how well she's doing in all the services she's in. I believe.
Is she here?
Yes,
I
she's right
am.
there.
Can you
Hello.
state your name, please?
Hello, Your Honor. My name is Emily Bates.
Thank you. All right, go ahead.
And I know that Mr. Feaster, Attorney Feaster, has done the same thing. We just have not gotten a response, but it's my understanding she's doing a lot of stuff and we just need it for mitigation. So I'm just asking for an adjournment.
Okay, you try to get that information for mitigation.
Yes, Your Honor.
Got it. Probable cause conference, February 20th, 2025, 9 a.m. Bound continues.
Thank you, Your Honor. And she has permission to appear by Zoom.
Your Honor, I'm sorry. Can I have it later? Can I have it again at 12:30 rather than 9 a.m.? Or 10:30 rather than 9 a.m.?
Your Honor, traditionally, she has been set in this particular block. But of course, Ms. Bates, that is up to the court.
I would appreciate it. I'm not sure if I can make it if it's too early because my case manager won't be here to let me in.
Ms. Bates, we'll talk about it and I'll make it,
Ms. Bates, I'll do you one better. Ms. Wiseman, can we make sure she goes in the afternoon? Yes. Thank you.
Thank you.
You're
Your
all
Honor.
set.
Thank you, Your Honor. Have a good day.
You too.
Thank you.
Ms. Cannon, don't be mistaken. I did that for her, not you.
I understand.
All right?
I understand.
Thank you. Clerk calls the case, People versus Richard Thomas.
Kyle Bedell for Mr. Thomas, who's approaching to my right. Please say your name for the court.
Rashard Thomas, Your Honor.
Thank you.
Your Honor, today is the date and time set for probable cause. Take your hands. Just put them up front of your hand.
Okay. Sorry, sir.
So today's the date and time set for probable cause conference. I was very recently appointed. Requesting an adjournment, I have submitted the form.
Probable cause conference, February 20th, 2025, 9 a.m. Or as your invite indicates. All right.
Thank you, Judge.
Thank you. Bond continues. Thank you, sir.
All right. Thank you.
Court calls case, People versus Brian Howell.
Good afternoon, Your Honor. Assistant Public really on behalf of Mr. Brian Howell. Mr. Howell, state your name for the record, please.
Brian Howell.
Your Honor, we're requesting an adjournment in this matter.
Wow, hold on. You're actually doing that. Okay, no. I was just shocked. Go ahead.
We're requesting an adjournment in this matter. We're trying to get Mr. Howell into a treatment court out of county. He lives in Oakland County.
Oh, okay.
We tried.
Go ahead.
No, we tried for a 14B, but he was not eligible
He's not
because of his address, correct?
So you're looking, how much, didn't we have this issue the last time?
We did have the issue the last time. We have not been able to find a out of county court that's willing to do a transfer. That's the really big issue that they have sobriety courts, but
The ones that we had reached out to just said that they,
All right.
we're hopeful.
February 20th, 2025, 9 a.m. Hope it will work.
Thank you.
All right, thank you. Thank you, Mr. Hall. Court calls the case of People versus Marcus Jones. Andrew Childers appearing on behalf of People.
Assistant Public Defender Asa Bashir here on behalf of Mr. Jones. Mr. Jones called me at 11:57. He's having some transportation issues. Or he's on his way, but he should be here shortly. I would
Hold on a second. This happened twice last week, right? And it was with you.
Well, there was one case where there was a transportation or a delay, I believe, last week. But yes, there were a lot of passes that involved me. Yes.
So what are you asking me to do?
I would humbly request that the court passes this case and recalls it later. He is on his way. He's going to text me right when he's here, and I can.
Why isn't he here?
He's taking the bus, and there was some delay with the bus.
And check and see if a bus broke down. I'll pass it. But if I don't get a bus breakdown, we're going to have a time.
To be clear, I'm not sure exactly what the specifics were, but I know
The delay?
Yeah.
He didn't get on the bus in time. That's what the delay, I can tell you what it is.
Thank you, Your Honor.
Court calls the case of the People versus Frankie, is it Len Young?
Yes, Your Honor.
Was that Gaddy? Oh.
London, Your Honor, actually, a lot of people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Lennon, who appears to my right. Miss, can you please state your name for the record? Your Honor, I am requesting a final adjournment on this matter. That's all we should need. Another $300 was paid. I checked in with the prosecutor on that, confirmed with the receipt. We're just asking for 4 weeks so that he can complete the restitution.
All right, close enough to be able to do it in 4 weeks? Sure. Probable cause conference, March 13th.
Okay, thank you, Your Honor.
Why were you surprised?
No, I'm not.
What's gonna happen is something will come up and then.
With me?
Well, that
I
too.
don't know. I don't think so.
But something will come up. You might have to do something, won't have it.
I have full faith in my client, Your Honor, that he will complete that. He's done everything that he needs to.
No, I'm not saying that. It's just sometimes life interferes.
I get that.
If you don't want me to give you the time, I'll just.
No, I think the 4 weeks is appropriate, Your Honor. If something happens, we will submit a stip in order to adjourn.
Not from the March 13th date.
Okay.
I gave 7 weeks.
Okay.
4.
Oh, you did. So yeah, we'll be fine.
Were you
within-
listening to anything
Listen,
that
I
just
was.
happened?
I
Never
don't-
mind. Sir,
went to
have a
law
great day.
school,
Bye.
Law school, not math school, Your Honor.
God, that's it. I'm not doing anything nice again, ever.
I don't do math.
Ever. No, not for you or Cannon. Maybe I can really get something, but probably not. Court calls the case, People versus Nakoa Nelson.
Assistant Public Defender. Sorry, Mr. Nelson. Go ahead and state your name for the record.
Nakoa Nelson.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Nelson. Your Honor, we're respectfully requesting an adjournment. Mr. Nelson is currently inpatient at Bear River. To my understanding, he's doing quite well. And after his completion of the inpatient treatment is expected to be moved to transitional housing. We're just asking for an adjournment so that he can complete the inpatient and we can have further discussions with the people regarding resolutions of all his matters.
All right. And when is he anticipated to complete that?
That I do not know, Your Honor.
Your Honor, yes, I complete tomorrow. So.
Oh, you do?
Yeah, I complete tomorrow, 90 days fulfilled.
All right. How's it going for you?
Great, great. So I'm planning on staying up here, in Gaylord. I'm going to a transitional house called Josh's house. So I don't know what's going on
Okay.
with sports and stuff, but it is 5 hours away from Ypsilanti. I just don't think Ypsilanti Ann Arbor is a good place for me, Your Honor.
Okay. All right, here's what I'll do. He gets out tomorrow. Let's give him a few weeks to try to get himself settled because he's going through that. So I'll adjourn it out to February 20th,
Thank you, Your Honor.
2025 at 9 a.m. All right, sir. So February 20th.
What time is that?
Well, I said it at 9 a.m., but your attorney will get an invite with the time block you're in.
All right, thank you.
All right. Take care.
You too.
Thank you, Mr. Nelson. Thank
Yes.
you, Your Honor.
Yep.
Court calls the case, People versus Antoine Patterson.
Last one. You're welcome, Your Honor.
Jacob Kennedy on behalf of the people here.
Assistant Public Defender Jay Valentin, on behalf of Mr. Patterson, who stands to my right. Mr. Patterson, can you please state your name for the record?
Antoine Patterson, Sr.
And Your Honor,
Yes, go ahead.
an offer was just made today. I'm asking for 4 weeks for my client to look into a few different things, consider the offer. The potential penalty could impact his ability to take care of his child, and his rights.
February 20th, 2025,
Thank you.
9 a.m. Write your invite. Thank you.
Okay.
Court calls case of the People versus Michael Primus.
Andrew Childers appearing on behalf of the people.
Public Defender Fellow Nicholas Bukovich on behalf of Mr. Primus. Oh, I talked to him.
Just push him out of the way, Mike. No, I'm kidding. All right. Your name, sir?
Michael Primus.
Primus. Okay.
At this time, Your Honor, Mr. Primus will be requesting a 1 month to 45-day adjournment to obtain retain counsel.
You want 1 month to get, you're going to hire your own attorney? Probable cause conference will be adjourned February 27th, 2025, 9 a.m. That's for you to get an attorney or private counsel. That's the only time you'll get an adjournment for that purpose. You understand that, sir?
Yes, sir.
Yeah. Court calls case People versus Ronnie Richards.
Echelon people.
Mike Getty, Assistant Public Defender on behalf of Ms. Richards, Your Honor. Sorry, I was just making sure no one else from my office was gonna jump on. Your Honor, I do have a green sheet here. I've submitted a green sheet on this matter. Ms. Richards, could you state your name, ma'am?
Ronnie Richards.
Thank you.
Your Honor, I've had a chance to discuss this matter with Ms. Richards and with Ms. Landy. There is an offer that I received. I didn't have time to contact Ms. Richards before court this afternoon. I'd ask for a very brief adjournment. I think we'll be able to resolve this matter next time.
Probable cause conference, February 13th, 2025, 9 a.m. Bound continued.
Hey, Ms. Richards, I'll give you a call when I get out of court, okay?
Okay, thank you.
Uh-huh.
Thank you. Have a
You're
good
welcome.
day.
Court calls the case People versus Eric Smith.
And on behalf of the people.
Public Defender Fellow Nicholas Bukovich on behalf of Mr. Smith.
State your name.
Eric Smith.
Thank you. You're requesting an adjournment?
Yes, Your Honor, of approximately 3 weeks to allow us to provide medical documentation that Mr. Smith provided me to the prosecutor and for further negotiations.
Probable cause conference will be adjourned February 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus William Sumler.
People.
Not here?
I sent a Zoom request. He said no because he needed to appear here in person. Guess there was some back and forth the last.
Sure, the court recalls that we tried to do a plea, didn't go through, he came back the next time, but it was carried on a phone, he didn't have any video capability, so the court said he had to be here first.
I've talked to him.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of 10,000. Cash surety, that warrant will issue immediately. Court calls case of People versus Donald Taylor.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Taylor.
Oh.
Your Honor, if the court's aware, you graciously granted an adjournment. Last time there was an active bench warrant. He was in the hospital. He had called our office, spoke to the hospital at the last PCC date. We never received any verification of his hospitalization. We did get in contact with his mom yesterday, but still don't have
All right.
any response. So I'd ask for an adjournment.
But this bench warrant is out, correct?
Yes, there's already a warrant.
We'll leave the bench warrant that is currently out. And I'll just indicate that it failed to. Thank you.
Thank you.
Court calls case People versus Adrian Vasquez.
Actually, line for the people.
Stephanie Scanlon on behalf of Mr. Vasquez, who will be appearing to my right. Mr. Vasquez, when you are present, could you please state your name for the court?
Adrian Vasquez.
Thank you. Need more time regarding discovery.
Yes, Your Honor. And I've emailed the appropriate people for the discovery. I did it yesterday. So I asked for 2 weeks. We're looking for body cam, dash cam, and there were a lot of DNA fingerprints. So there's a lot of lab stuff as well that needs to come back. I'm not sure how long they are requesting, but we can do 2 weeks to see if we got it in.
February 13th, 2025, 9 a.m. Bond continued. Thank you. Court calls case People versus Vershawn Vincent.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Vincent. I believe should be on Zoom, Your Honor.
There he is.
Thank you.
Mr. Vincent, can you state your name, please?
Yeah, Vershawn Vincent.
Thank you.
Your Honor, we're asking for an adjournment. Mr. Childers regarding this case. So we're asking for some more time for negotiations.
Probable cause conference, February 20th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Thank you, Mr. Vincent. Court calls case People versus Christopher Waldecker.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Waldecker. Mr. Waldecker, will you state your name for the
Christopher
record?
James Waldecker.
And I have a plea form in front of me. Is that what we're doing?
Yes, Your Honor.
All right. The plea form indicates that defendant will be pleading guilty to attempted resisting and obstructing a police officer, that being count 2, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Yes, that is correct, Your Honor.
All right, very good, Nate. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but so help you God?
Yes,
State your name.
Christopher James Waldecker.
All right, sir, it is the court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that, sir?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that, sir?
Yes.
And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On May 24th, 2024, at the location of East Willow Road near Sanford in York Township, Washington County, state of Michigan, did you come into contact with police officers?
Yes.
What happened?
When I passed, he had to turn his lights on. I passed him and continued to go. So for just a few minutes.
Mr. Waldecker, Your Honor, may I?
Yes.
Mr. Waldecker, at that point, you knew that the officers had pulled out behind you
Yes.
and turned on their lights to pull you over?
Yes.
Okay, and you knew that that was an officer giving you a command to stop?
Yes.
And you failed to stop, correct?
That's correct.
Counsel, have I complied with the court rule and would it be proper to accept this plea?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be March 18, 2025, 9 a.m. before Judge Freshour.
Thank you,
Bond.
Your Honor.
Thank you. Bond will continue. Court calls the case of the people versus Ryan Wheeler.
Ashley Lonnie for the people.
Ron Brown appearing on behalf of Wheeler.
Please introduce yourself.
Ryan Wheeler. Thank you. The request again is there, Mr. Wayne.
Yes, Your Honor, we just received the media and I wanted to share it with him.
Probable cause conference will be adjourned February 13th, 2025, 9 a.m. Bond continued.
Thank you. Thank you.
Your Honor.
Thank you.
Court calls the case People versus DeAndre Wilburn.
And on behalf of the people.
Public defender fellow Nicholas Bukovich on behalf of Mr. Wilburn.
Your name? Oh, DeAndre Wilburn. All right, what are we doing?
At this time, Your Honor, we'll be setting this matter for preliminary exam.
All discovery is complete.
Yes, to my knowledge, Your Honor.
Good. The people have their witnesses available on the 11th.
Do our best, Your Honor.
Preliminary examination in person will be set for February 11th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case of the people versus Luther Williams Jr.
Luther Williams Jr., Your Honor.
Yeah, the assistant public defender for Mr. Williams. Your Honor. Your
He's
Honor,
already told us who he is.
Your Honor, we'd ask the court to set this matter for an exam.
For preliminary exam. All discovery is complete.
To the best of my knowledge, information, and belief, Judge.
Well, all that? Okay, would people have their witnesses available the 11th? Preliminary examination in person will be set February 11th, 2025, 9 a.m. That is before for me. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Jade Wimberly.
Stephanie Can on behalf of Ms. Wimberly, Your Honor, who is not present today. I would just ask for an adjournment.
Question about that. Not here.
Nope, nope, nope.
You don't have to say anything, don't worry. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000. Cash surety. That warrant will issue immediately.
Thank you.
Thank you. Court does call the case of the people versus Douglas Wren. 3 cases.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Nazi Carey, I can rule, Your Honor, on behalf of Mr. Douglas Wren. Mr. Wren, state your name for the record.
Douglas Wren.
Thank you.
Your Honor, we're requesting an adjournment. Mr. Wren is currently in treatment right now, and we're just trying to see if a positive outcome of treatment would allow us a better offer from the people.
Are there other matters pending or?
Not that I.
No, okay. Because you put on here global resolution. Are you looking so to resolve all the 3 matters he has before?
That is correct. In this, yes.
Okay, so. And
Yeah. Last week,
okay. All right. So,
transitional housing.
okay. So, Your Honor, I think maybe 2 weeks, he says he just completed treatment and he just moved over to transitional housing. So if we can get that and maybe some mitigation information to the
Got it.
people.
Okay.
I'm also in outpatient, Don Farms outpatient.
Okay, so you're doing Don Farms outpatient
And transition.
and transit. Gotcha. Okay. Well, let's give him same thing that I did on that other one. I'm gonna give him time to sort of adjust to what he's now doing. All right, get the information to you and then do that. So I'm gonna go to the 20th, February 20th, 2025. How's it going for you, sir?
Great.
Is it?
Yeah.
Fantastic.
I have a new phone number.
Who's that?
I would need that.
That was Peyton Cannon? Peyton and Cannon? Being that loud?
It wasn't me, Judge.
Yeah, but if you had been walking out, you would have been all in.
Louder.
I'll turn it out to that date. Bond will continue. Good luck.
Thank you so
Good luck to you, sir.
Thank you.
All right. What did I say, the 20th? I have to go over there and talk to them about that. Is that it for that block? Oh, yeah, hold on. Trying to buy her time. I ain't buying you that much time. I'm done writing, so your time's up. He's not here, is he?
My colleague is checking the hall. I understand any decisions are at the court's discretion, so I.
Absolutely. That's how we roll. What'd you say?
Isn't it always true? Not just this court, but just in all courts, ultimately make all decisions.
Yes.
So, this is true. I'm just kind of stating the obvious there.
So which colleague of yours was checking?
I might.
So he's walked out. We've lost both of them. Not here?
I don't know if you want to. I'll wait.
You know, I'm gonna wait for you to sit down and then call the case. No.
I jumped the gun.
Counsel, here's what I'll do. Sooner or later, you'll learn not to do this. What I will do is I'll put it to the beginning of the next block.
Thank you, Your Honor.
I don't even know why I'm doing that. I don't even know why I'm trying to be nice. That's what?
The weather's nice out. It's a sunny day, the sun's shining.
I've been inside all day. Thanks for reminding me, boy. Now you put me into a
I only
bad.
know that.
example. All right.
I appreciate the grace that you're offering our client. Thank you.
You know, I only did that because Alan said do it. Otherwise.
Thank you, Alan.
What are you doing? I do see him. in-
So what's the from this morning that we have listed as pro per? He says he's here on this case. Obviously, we don't
Oh,
have the AG and defendants in federal custody.
oh, gotcha.
So I don't know if you would.
That's why Mr. Perkins is here. Let me, on the Brian Brown matter this morning, Mr. Perkins, I guess I'll call the case. I issued a bench warrant this morning. We didn't have an appearance from you. I don't know. That's on our end or what?
I
Go
filed it
ahead. What did you say,
twice.
sir?
I had filed it. You had told me the first time I was in for a PCC.
Yeah.
And I filed it then, and apparently at the shortly after the arraignment, it was filed. So I'm not sure, but I'll get another appearance in. But unfortunately, the relief I'd be asking, Your Honor, is to set aside the bench warrant and reset it for another date next week. But I was going to make a motion for stay because Mr. Brown is now in federal custody. He's not, unless he's written out. But I was going to ask for a stay, and perhaps even after the stay, ask the AG to dismiss this case because Mr. Brown faces some substantial issues that.
Otherwise, gotcha.
Yes.
All right. Well, here's what I'll do. I'm gonna set it for another date, but I'm gonna leave the bench warrant outstanding.
Okay.
All right. So I'll set it. Will the 6th or the 13th work for you?
The 6th is better. I just want to get the warrant set aside. He's not going to be present, so I'll be asking to waive his
No,
presence.
I understand that, but
Okay.
just to get it there, and I don't have the other side here, so I'm
Right.
just
Is
trying
that
to.
in the
Okay,
morning or is that 12:30?
that would. We could do. Would morning be better for you? Or
Either one, whatever the AG's
okay,
gonna be
we're
there.
gonna set it in the morning.
Okay.
Okay,
All right.
because that's all right. So we'll set a date out of February 6th,
Okay.
2024, 25, 9 a.m. All right.
All right. And tell your staff, thanks a lot.
Thank you.
Thank
sir.
you.
All right. I don't know what, do I need a new Carol or?
I was told there was a blank here. On there for you.
There is, but I'm leaving the bench warrant out.
Okay, I'll add to the other one. So-
Thank you. You'll do it. That was pure laziness on my part. But I learned that from McEnroe. All right. Wow, he said that out loud. All right. So this is your case. That's Jones, right?
Yeah.
Oh, that's why I still have a file up here. That's right. Never mind. We'll call it up in the next block. Court's gonna stay in recess.
Session, the Honorable Judge Cedric Simpson presiding.
Friedman is just here every day. He enjoys games? I don't think so. I think he'd be on a bird headed south if he could. Court does call the case, People versus Marcus Jones.
Andrew Childers appearing on behalf of the people.
Ms. Bashir, you are the luckiest person in the world.
Assistant Public Defender Asli Bashir here with and on behalf of Marcus Jones. Mr. Jones, you can say your name.
Marcus Jones.
Thank you. You need an adjournment of these proceedings.
Yes, thank you, Your Honor, for further negotiations with the people.
Probable cause conference is adjourned February 20th, 2025, 9 a.m. or as your invite indicate. Bond will continue. All
Thank you, Your Honor.
Thank you. Thank you for making it, Mr. Jones. Look at that. Court calls the case, People versus Demita Brown.
Echelon, defendant.
Ready, Your Honor.
Good afternoon, Rob Chico on behalf of Brown. And would you
afternoon.
state your name for?
Demita Brown.
Judge, today's PCC, can we set an exam date on this, please?
All your discovery is complete.
Yes. Yes.
Yes. People have their witnesses available the 11th. Preliminary examination in person, February 11th, 2025, 9 a.m. before Judge Valvo.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you.
Please call me.
Court calls the cases of the people versus Jeffrey Penn.
Good afternoon, Judge Lawrence H. Margolis with and on behalf of Mr. Pence, who is here to my right. Sir, please state your name for the court.
Jeffrey Pence.
Thank you.
Your Honor, we are set today for the competency review in this matter. People are going to be filing a nollie in this case. Based on the conversations I've had with Mr. Margolis as well as Mr. Childress regarding this case, we do not anticipate a mental health order being filed. I can supplement the record on that in writing if the court prefers. Because Mr. Margolis is on Zoom, I would approach, but it may be difficult. It is contained in the report, the nature of Mr. Pence's invitation, which may educate the court as to why we won't be filing that.
I am very familiar with this case, given the, I guess, alleged bond violations and other things in Mr. Penn's conditions. And so, well, you don't need my concurrence in it. I do concur in that. I think it's the appropriate just response.
Thank you, Your Honor.
Thank you, Judge.
What happened?
And ma'am, how are you doing?
Hello, Your Honor. I'm doing okay. How are you?
I'm doing all right. All right.
Good
You
to
guys
see
take care of each other. This
Thank you very
case,
much.
I can dismiss. You're welcome. I can dismiss this now and you'll follow.
Yeah, we'll get the paperwork over probably by tomorrow, Your Honor.
This case is dismissed.
Thank you, Your Honor.
Prosecutor's motion. All right. You two take care of each other, please.
Thank you very much.
Will do, Judge.
Court calls the case, People versus Earl Carver.
And then on behalf of you.
Your Honor, Alice Friedman on behalf of Earl Carver, he's present. State your name, please.
Earl Carver. Thank you, sir.
And Your Honor, my mistake say that the defendant will take count 2 with sentencing under 769.4A, and count 1 in return will be dismissed with an agreement between the parties to no upfront jail.
That's correct.
And count 1 will be dismissed. Is that
Correct, Your Honor.
all right? He signed in advice, right? And in terms of since it's not my case, I just indicate I cannot bind the sentencing judge to any of that, but I don't see it. Why?
We will waive sentencing, Judge.
No, I'm going to send it over there. I don't see that she won't follow it.
No, I.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Earl Carver.
Sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
What was that again, sir?
That you're going to be pleading guilty to the offense. Are you having problems hearing me? Or
Oh, it's just the echo, sir. That's all.
all right, let's see if we have some equipment. Let's see if the worst thing in the world would be if my voice was echoing.
Okay, thank you.
All right, does that help you?
Yeah.
Okay, all right. It's the court's understanding that you're going to be pleading guilty to the charge of domestic violence. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in 14A4 District Court. You understand that, sir?
Yes, sir.
That's the court for out county.
Huh?
That's the court for out county.
Yes.
Okay.
Well, we're out county too.
Kind of.
No, because in county is really Ann Arbor, and we're not Ann Arbor. We're proudly Pittsfield. Thank you.
All right.
All right. But not going to get into a big debate. Actually, her proceedings will likely be here in this building because 4 is closed. So, all right. All right. You understand all of that, sir?
Yes,
All right. Understanding that you still do wish to plead guilty?
yes.
All right. To the charge of domestic violence, how do you plead?
Guilty?
Yes, sir.
Guilty.
All right. Now you understand that by pleading guilty, you will not have a trial of any kind.
You will not have any kind of trial.
Yes,
All right. You signed an advice of rights form today. Is that correct, sir?
yes,
All right. You have any questions regarding any of the rights on that form?
no,
All right. If you look on the podium, there's a copy of that form, and you understand that you're waiving. If you look, you'll see paragraph 5. It's the highlighted paragraph. And you understand that you're waiving those rights as well as all of the rights that are on the form.
Those are your trial rights and you're not going to have a trial. You understand?
yes. Okay,
right.
yes,
You understand also, sir, that you're giving up your right to appeal of right.
yes,
All right. Are you on probation? Are you under the jurisdiction of any other court?
no.
All
no,
right.
no.
Are you on parole? You've never been to
No.
prison, right? Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
and of your own free will,
yes,
and because you believe that you're guilty of this offense?
yes,
All right. On the date of December 31st, 2024, at the location of 9560 Keys Road, Manchester, Michigan. What happened between you and Cindy Carver that makes you think that you're guilty?
we just had an argument and I shoved her.
All right. And you didn't have her permission to do that, did you?
No,
And you did that on purpose, sir?
I guess.
Well, when you say you
It wasn't
got,
an accident, was it?
Yeah, huh?
It wasn't an accident.
Okay, all right.
well, was it an accident or did you push her on purpose?
Just pushed her on purpose.
Yeah.
Yeah, just pushed her on purpose.
Okay. And who is Cindy Carver to you?
My wife.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
I believe so, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
March 18th. Oh, I'm sorry, no, it's February 13th at 9:30.
second what?
February 13th at 9:30.
February 13th, 2025, 9:30 before Judge Fresho.
Thank you, Your Honor.
All
I
right.
spoke with Mrs. Carver yesterday. And I spoke, she asked me to ask the court if it would be, if we could change the bond conditions and allow Mr. Carver to return to the marital home. They've been separate now since January 3rd or December 31st. He has complied with his conditions of bond. They have not met with each other. They have not talked to each other. All they have done is communicate electronically regarding business and the 2 businesses that they have as you ordered. But they both believe that they can reside together without incident. He's receiving some different medication than he had, and he feels like he's ready, willing, and able to return, and she is too.
Any response from the people?
Your Honor, I'll leave it to the discretion of the court.
Mrs. Carver's here if you wish to inquire.
Yes, is she here? Or can you come up, ma'am?
Right, yeah, okay.
Just have a seat.
Hello. What's your name?
Cynthia Carver.
All right. And you wish the court to basically adjust the no contact provision and also allow him to return to the marital home?
Allow me to return to the
Allow-
home.
She's the one that moved out.
I'm the one who's out.
That's right. Now I recall. So you want the no contact done, right?
Lifted, yeah.
Lifted, because, well, did we, now that I think about it, Did we preclude him from a certain residence?
That Keys Road originally, then we modified it that he goes there because there's livestock there, and she went to the cottage, and the cottage is getting cold, and she'd like to go back to Keys Road, and the switch doesn't really work because she wants to take care of the livestock.
She wants the heat.
I
Yes.
believe the threat's lifted. It's not there. I don't feel threatened at all.
I just want to make sure I will change it, but I'm just trying to make sure I change it in the way we don't have that entered into our system at all. What I'm going to do is this, and we'll have to figure out the logistics of our order to make sure I'm going to lift all of the no contact or all of the no go to provisions. I'm going to modify the no contact provision to allow contact, consensual, no non-consensual contact.
Okay.
So as long as you're in agreement that you can have contact, then that's it. Okay.
Correct.
Sir, what you'll need to understand is that if you're in one of the homes, she's there, and all of a sudden she decides she doesn't want to have contact with you, you're required to leave. You understand that? Okay. So I will grant that change, and then we'll make sure that the orders match so they reflect what I've just told.
Great.
Thank you.
All right.
Thank you, Your Honor.
We're all set. Court calls the case, People versus Stephanie Martin.
Good afternoon, Your Honor. Allison Castles on behalf of Stephanie Martin, approaching to my right.
Your name?
Stephanie Martin.
Thank you.
Your Honor, we would just ask to adjourn this matter out for a couple weeks to allow for further discovery.
Without objection, probable cause conference will be adjourned February 13th.
Your Honor, would it be possible to delay that out until the 27th?
You know what? She's doing a Garen.
Oh.
Because she asked for a couple weeks, didn't she? Is that what I heard? So hold on, I got a calendar person. Emily, 2 weeks out is what date? The 13th. I got it right? The 27th would be how many weeks? That'd be 4. Okay.
I'm sorry.
So
about that.
which would you like, counsel?
The 27th, if you'll allow.
I almost want to say no, but I won't.
Thank you.
February 27th, 2025, without objection at 9 a.m. or hearing indicates bond will continue.
And if I may address travel, Your Honor.
Oh, man. Go ahead.
Ms. Martin.
This is definitely Garen. You wait till I'm done, everything's going along. There's like, by the way, go ahead.
Ms. Martin's asking to travel to Florida to visit family from February 18th to the 25th.
February 18th through the 25th.
Yes, Your Honor.
What part of Florida?
Venice.
Any objection from the people?
I'll leave it in the court's discretion. Your Honor.
We'll indicate that defendant may travel to Florida February 18th through the 25th inclusive. All right.
Thank you.
Court calls the case, People versus Devin Morgan.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Dan Guerin on behalf of Devin Morgan. State your name, Doug.
Devin Morgan.
There should be a green sheet in the file. I am requesting 4 weeks. For
Oh, no, you know what?
What?
Here's what I'm going to do.
What?
I'm I was thinking about this.
Yes.
And I bet you Karen's gonna come up here
Right.
and ask for an adjournment. He's gonna ask for an adjournment to set it on the same date that she's appearing.
Well, just specific number of weeks I think is important to ask for. Don't you? It's our words carefully.
You are. You're just messing with my head. I'm not gonna play. All right. What I'll do is I'll adjourn it. Probable cause conference to February 27th, 2025, 9 a.m. or as your invite indicates, bond will continue.
Thank you very much. Ryan.
Thank you.
Have a good day.
Wow. And then Dan then took a shot at her by saying specific. He's so mean sometimes. Court calls the case, People versus Alan Maloney.
Actually, one of the people vote matters.
Thomas Stringer appearing on behalf of Mr. Maloney, who is present, and we could state your name for the record. Alan Maloney.
Good afternoon to both of you. All right.
Afternoon, Your Honor.
What are we doing on this?
Your Honor, we're going to waive the exam and ask the matter be
bound over.
Bound over.
All right.
We are going to ask for sobriety court, but I know you have no input into that.
When you get there.
Yes.
Gotcha. All right. Sir, you're waiving your right to a preliminary examination in both of these cases?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged committed and that you committed them.
I do.
And you understand that you will not have that hearing and that you'll proceed to circuit court for further resolution.
I do.
Wait, right?
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on the 4 counts, both 1 and 2 in each case, with 3 following in each matter. Mr. Stringer, as to the circuit court arraignment, you waive formal reading, your client stands mute.
I do, Your Honor.
Defendant every waive formal reading, standing mute to all charges. Court will enter a not guilty plea as to all charges. Pretrial in circuit court will be set for
March 25th.
March 25th, 2025, 1:30 before Judge Coe.
Judge Conkey, that was your?
Yes, sir.
All right. Thank you.
Bond will continue with its condition.
Thank you.
Thank you, Your Honor. Good seeing you again.
Court calls case, People versus Lawrence Lewis.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Wonderful to see you on this beautiful day.
Oh no, what are you asking for? Good to see you also.
Robert Ellman on behalf of Mr. Lewis. Your Honor, as you can see, Mr. Lewis is not here. I have prepared a green sheet. However, I didn't turn it in because I didn't know with not being here if you'd accept it or not. I was going to be asking for an adjournment if Mr. Lewis did appear. As there, I believe, and Mr. Childers, please correct me if I'm wrong, we're looking into some outstanding discovery. I believe I'm still waiting on potential body camera footage from Ann Arbor PD.
Yes, I believe you were on that email I think I sent yesterday to AAPD requesting the same. So I do agree that there appears to be some outstanding digital discovery.
And so, Your Honor, on Mr. Lewis's behalf, I would like to say that he has contacted me since I was appointed to represent him. He did inform me he does not have a phone, and he did come to my office for an appointment. So I don't know if this was a scheduling mistake on his behalf, but so far, except for being here today, he's been active in his defense.
Bench warrant will issue for defendant's failure to appear. Bond 10,000, cash surety. That warrant will issue immediately. But it was great. You were eloquent as heck.
Have a great day, Your Honor.
Yes, you don't mean that, but thank you. All right. Court calls the case, People versus Charles Tinsley.
Ready.
Your Honor. Take care of the people.
And Your Honor, Joe Simon on behalf of Mr. Tingley. Mr. Tingley, please state your name.
Charles Tingley.
Thank you.
Your Honor, this one I believe is requesting a brief adjournment for waiting for your benefit regarding the state polygraph examination.
Hearing.
State polygraph examination schedule.
Would the 20th work?
Your Honor, we don't yet have dates from Detective Babich. He's supposed to.
Gotcha.
And in addition, my client will have to do some significant travel. He has medical limitations. So I think that's a little ambitious, the 20th.
So how many weeks do you guys think you need?
4 weeks, I think, would do it.
You want the 27th or the 6th of March?
Your Honor, since Mr. Babich, Detective Babich, pardon me, give us dates until next week, I think it's smarter to do the 6th, if that's possible.
Probable cause conference, March 6, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Thank you, Your Honor.
Court calls case People versus Jeremy Troutman.
Both you, on behalf of the people.
Your Honor, Dale Smith, on behalf of the defendant who's present and sits to my right.
All right, sir, can you state your name, please?
Jeremy William Troutman.
Thank you. All right, what are we doing?
Your Honor, I have not. Go ahead. Go ahead.
I was asking you what we're doing.
Okay, awkward. What are we doing? What are we doing, Mr. Smith?
I have not had the opportunity to see the police report. We haven't exchanged any discovery yet, so I think we need to adjourn this, Your Honor, if you don't mind.
All right, yeah, we'll do that.
Mr. Smith, I'm going to email you where to send your discovery request.
Thank you.
Probable cause conference will be adjourned February 20th, 2025, 9 a.m. or as your invite indicates. Bond will continue. All right.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Brandon Baker.
Ready, Your Honor.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Nicholas Stern on behalf of Mr. Baker appears before us via Zoom. Mr. Baker, if you could please state your name for the record.
Brandon Baker.
All right. What are we doing?
Your Honor, I am in need to get discovery. I now know the prosecutor's Mr. Childers. I'm going to reach out to him and get that. I would respectfully request the 20th for an adjournment so I can get that, speak with Mr. Childers.
Oh, you learn real quick. You don't get to pick your dates, but I'll give you the 20th.
The only reason I say that, Your
20th.
Honor, is I have 2 in-persons and the 13th and the 27th. I have an evidentiary hearing, so I would have had to ask you to give me a different date.
They're waiting. They'll wait. February 20th, 2025, 9 a.m. Bond continued.
Thank you very much. You have a great day.
You too.
Mr. Childers, I'll reach out via email.
Thank you.
Court calls the case People versus, is it Grisha Cheatham?
County for the people.
Gracia Cheatham.
And good afternoon, Your Honor. Rita Young, P44626, appearing on behalf of Ms. Cheatham, who just stated her name for the record.
All right. And what are we doing today?
I'm requesting an in-person preliminary examination, Your Honor.
All discovery is complete.
Your Honor, all discovery is not complete at this time. There's still the outstanding issue of the CSAM videos that need to be reviewed by counsel. Then we can get something set up with YPD in order for discovery to be complete.
Well, Judge, I know Ms. Tanda has been in trials, but I've been communicating with her to go to their office to view the video, but I don't think it's necessary to not set the preliminary examination hearing. I will get.
But you also understand that if you don't see that before the date I give you, that's not going to be a basis to adjourn. Your client is going to have to proceed without that information.
Okay, Your Honor, this will be the fourth PCC adjournment, but okay.
So you'd rather just adjourn the PE and have all the witnesses come in? I realize your distress. I would wish that everything would be ready on the first day, but I realize that it's not. So I just deal with the practicalities of it.
Okay, so I will trust the court's judgment and ask
Well,
for
you don't have a
another
choice.
PCC date. And Judge, can you order the prosecutor to set a date and time for me to come to their office to view it? Because everybody's always busy.
We're happy to communicate, Your Honor.
Who is speaking now? Because Ms. Tanda's who I've been dealing with.
No, that's some guy named Kennedy.
May I have Mr. Kennedy's first name?
No, he's not giving it out to you.
If you ever want, when you retire, Judge, I'll be your agent if you want to be a comedian.
Wow. Okay, that was kind of backhanded. You know, I'll go toe to toe with you, Miss Young. You know that. Counsel indicates he'll reach out to you to get a time set and everything. All
okay,
right.
thank you. You have a great sense of humor, Judge. That's why I said that.
Is that? I don't know. Okay, I'll trust you on that. Will the 20th work for you, Miss Young?
Just 1 second, Judge, please.
Mm-hmm.
Would that be a morning or afternoon PCC?
Usually, typically for you would be set in the afternoon.
Okay, that would work great.
So, that'll work? Okay. February 20th, 2025. I'll set it at 9 a.m., but you'll get your time block. And like I said, the private counsel is usually in the afternoon.
Yes, Your Honor.
All right. Why, you want me to give you a particular time?
Yes, please, if possible. 1:30.
No, I don't give us. I don't. No, I'm not doing that. Why would I do that just for you? I've done it for nobody else today, and for the last 5 years at least.
Okay, me apologize.
That was a half-hearted apology. We'll see you on the 20th in the afternoon.
Very well, Your Honor. Thanks again.
Thank you.
Miss Cheatham, I'll be in touch. You can zoom out now.
Okay.
Court calls the case, People versus Shayla Gilden.
Alexander, people.
Is this it? And
Yes.
this is all. Hello.
Hi.
First thing, we received a message from your counsel currently of record, Ms. Tieppo, indicating that she had a medical emergency with a child. However, sent no documentation. Okay. So here's what I'm going to do, ma'am, and I hope it doesn't inconvenience you too much, but I know we had to do a warrant recall on this. I'm going to adjourn this out a couple of weeks. But I'm doing two things here. I'm going to adjourn your probable cause conference out to the, probably should go to the 20th. Okay. February 20th, 2025 at 9 a.m. or as your invite will indicate. And so you might want to just check with the court when exactly it is, or your attorney of record, which is currently Ms. Tieppo. I'm also setting a show cause for defendant's counsel for her failure to appear today. Now, I will cancel the show cause, as I've indicated in an email to her, if she provides adequate documentation of the medical emergency which causes her not to be here. Okay?
Okay.
All right. So that doesn't have a great deal to do with you. All right. You're okay. I just need you to appear back here on the 20th, 2025. All right? and your bond at this time will continue. All right? Thank you, ma'am.
Your Honor, would you also like, would you also like me to come back on the 20th on the same date?
Aren't you here like every week?
Most weeks, Judge, I am. But I want to make sure that I'm here when I'm supposed to be, so I got to put it in my calendar.
Yes.
Okay.
Anne said, yeah, for you to be here, because I was going to say no.
Oh, well, perfect.
Yes. If you could be here, if you could, counsel, and I understand why you're asking.
All right. Thank you, Judge. I'll be here.
Thank you. Court does call the case, People versus Ricky Lee Parvin.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Jennifer Winstead. I'm appearing on behalf of Ricky Parvin, who is present by Zoom.
Parvin, can you state your name, please?
Ricky Lee Parvin.
Thank you. All right, what are we doing on this case?
Good afternoon again, Your Honor. We are asking to adjourn out for a few additional weeks. We are still missing some crucial discovery in this matter.
All right, will the 20th work for you?
Yes, sir, it will.
Probable cause conference will be adjourned February 20th, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Thank you, Your Honor. Have a good day.
You do the same. Thank you.
Thank you.
Thank you. Court calls case of People versus Eric Lee Sibbett. All right. Right.
Yeah, he's there.
Back on the record in the case of the People versus Radcliffe. Counsel is present along with the defendant. Mr. Thomas, you may proceed.
Thank you, Your Honor. And Judge, I would just like to address what we were last talking about before you left. And
yes, sir.
It's page 5 with victim D and victim E. And I went back and I've looked at these things. And again, Judge, if the court has any concerns regarding my client with that type of contact, the one thing I would remind the court of, one, if it did happen, then I would say, obviously he wasn't under a court order or anything at that point. And so I understand the court's concern, but we would be willing to, have no contact orders, take away, and give up on any electronic devices, no phones, no computers, none of that. And I think that would obviously put to rest any possibility of him. And obviously, if he violated that, he would be right back here in jail. It would not be wise for him to do that. It wouldn't be wise for him to contact that. And honestly, Judge, it would be contrary to what I would advise him to do.
Well,
so
right. And let me make myself clear that I'm not saying that he violated a condition of bond. I'm not saying anything along those lines. I'm saying what troubles the court is that behavior where there are these allegations that are out there, and then behavior to, so I'll put it in the colloquial, just to either cover up or interfere with and or obstruct an investigation. That's what bothers the court. I'm not saying that he should be charged with anything. I'm not saying that. I'm just looking at the behavior of the defendant, because that's what I've got to bank on if he were to be released. And I'm pointing out what at least is alleged, a behavior that is very troublesome for the court.
And does this go to risk to the community, Your Honor, that you're talking
It
about?
certainly goes to risk to the community, and in my experience, also would go to the issue of, can I trust this person to not flee? Because in some way, this can amount to some type of obstruction of justice or some type of interference with an investigation. And do I believe that that person, assuming, and I'm not saying, not trying to necessarily make an accusation, but if somebody were to do that, can I trust that person not to flee the jurisdiction?
And again, Judge, I'm sure you've been doing this a long time. I've been doing this an awful long time myself. I've had, this is not my first bond hearing. I understand the court's concerns and under the circumstances when you have somebody that's got no prior criminal history whatsoever, you've got somebody that's never lived outside of Michigan per se, other than being in Virginia for Liberty for school for whatever that time period was, that has lived here his entire life. His entire family resides here. He doesn't have a passport. So it's, with the lockdowns that they have today, I mean, it's probably pretty impossible to try to get off, out of the United States without a passport. Obviously going anywhere else in the country, with the computer system, the NCIC and everything else that's out there, makes it almost impossible for somebody to just disappear and never be found again. It doesn't happen. I mean, I don't think I can think of one case where I've ever seen as an attorney where somebody didn't show back up.
But counsel, it isn't even the issue of will they be found again. It's the issue of will you attempt to try to flee the jurisdiction. I mean, and it's a slight distinction, but there's a distinction in it. So
I'm just saying, Your Honor, with the bullet points that I've already presented to the court, that he's not an alcoholic, he's not a drug abuser. He's had a job his entire life. He's got family and friends here. There's nowhere for him to flee. He's not going to flee. I don't think the court has anything to worry about with the fleeing portion of this. And I don't say that lightly, Your Honor, because I understand the severity of these charges. I get the concerns of the court, and I don't take that lightly. I don't take my position as his attorney lightly in that matter. And so, I drive 2.5 hours to get here every time I come here. I certainly don't want to represent a client that I would think is going to flee the jurisdiction and not do what I'm telling him and directing him to do. I certainly would direct him to make sure that he's in court. He knows what the evidence is at this point, Judge. And I told him, obviously we're here to defend this, and he's here and he wants to defend it. And obviously that is our goal, is to get through these PCCs, get through the preliminary examination, and let the chips fall where they fall. When we get through the preliminary examination, then if any charges that still exist after a preliminary examination, then we'll deal with that in circuit court. So obviously, our position as Judge is that he's sitting in jail for 105 days. The evidence in this case just, to charge people with CSAM and not have any CSAM just doesn't make any sense to me. And then to file more charges for the same charges without knowing that you didn't have any CSAM doesn't make any sense to me either. So in light of all that, Your Honor, just the magnitude of these charges that are presented on top of him doesn't mean that, hey, there's more charges I'm going to take, possibly be a flight risk or a danger to the community. He wants to face these charges. He wants to exonerate himself. That's what he wants to do. And so with that being said, Judge, my client is going to appear for these court dates. He's going to appear with me. And again, he's got all these people that are supporting him. He's got the letters that were presented to the court. He's got a place to stay, and we will give up any electronics. We will give up anything the court wants. If you want to put a tether on him, we'll do the tether. We'll put him, no contact orders. Take away all electronics. Anything that the court would make it feel safer for him to be out. He's going to get a job, and he's going to go to work, and he's going to live with his family. He doesn't need to have access to any of that stuff. So the court can put those no contacts, and if he violates, then throw him back in jail and keep him there. I have no problem with that.
All right. Thank you. Ms. Riser.
Thank you, Your Honor. I would indicate to the court that the defendant was arraigned and arrested on or about October 20th, 2024. At that time, Magistrate Fink set the bond at $3 million, no 10% cash or surety. Once the defendant was arraigned, additional victims did come forward. At the time of arraignment, he was charged with 1 count of criminal sexual conduct in the first degree, with 1 listed victim and additional approximately 11 additional counts of child sexually abusive activity and using a computer to commit a crime with different victims than the listed victim for the criminal sexual conduct first degree. When the additional victims came forward, the defendant is now, after the arraignment and the bond being set at $3 million cash or surety, facing 6 additional counts of criminal sexual conduct in the first degree with 2 separate victims. And I state that because the court rule in the statute allow this court to deny pretrial release of a defendant charged with criminal sexual conduct in the first degree if the court finds the proof that the defendant's guilt is evident or the presumption is great, unless the court is presented with clear and convincing evidence that the defendant is neither a flight risk or a danger to the community. And I would submit to you first and foremost, Your Honor, there was no abuse of discretion in the magistrate setting the bond at $3 million, but if we're going to look at the bond that was set at $3 million, the things that have changed since that bond was set is additional victims have come forward. So it would not be appropriate to reduce the bond. And in fact, the people are requesting that the bond be denied because there's no clear and convincing evidence that the defendant is neither a flight risk nor a danger to the community. This information in the investigation began on or about August 26, 2024, when it was reported to the police department, to MSP. One of the victims reported to the defendant's girlfriend at the time the things that the defendant had done to him. When his girlfriend at the time confronted him about that, confronted the defendant, she had a 6-hour longer conversation that night discussing the victim that had come forward. The defendant told her not to believe a word that he said, and he left her house around midnight. He told her that it was best that she not tell anyone that the majority of their conversation was about that victim. And he reminded her that they still had a 2-week break left in their relationship and not to contact him. Another victim came forward, and that's when she broke up with him. After that conversation, on August 30th, 2020.
Excuse me one moment, sir. Counsel, when you want to talk to your client, make sure to push the button on the top.
Yes, sir.
These microphones are very sensitive and I don't want a conversation. All right, go ahead, Ms. Rice.
On August 30th of 2024, the defendant then called that victim 8 times and told him that he needed to keep his, quote, fucking mouth shut, end quote, because there was no information that he could tell Brianna. And that's referenced in page 8 of the people's motion. So this is information that the defendant, that we have during this investigation. This is how he's acting when he's not been charged, when he's not been arrested and not been arraigned. He is intimidating and threatening the victims. And I would submit to this court that he is a flight risk. During the investigation, on October 21st, 2024, the Michigan State Police interviewed the defendant's parents. He was informed by the defendant's parents that the defendant went to Virginia after news of this broke. He may have stayed with his college friend Phil, whom he knew from Liberty University. His mom thought that she went to stay with her sister Rhonda in Indiana after he left Virginia and gave Rhonda's address. Rhonda dropped off 2 suitcases of Zach's to Frank and Robin. Frank went through the luggage and found a MacBook inside. The trooper took custody of the laptop. Robin and Frank did not know the passwords to any of the devices. The defendant's mom cried during the interview and said that Zach had been leading a double life.
Counsel, I don't want to interrupt you, but I want to make sure that I'm understanding this. In October of 2024, the defendant, after the investigation starts to happen, he leaves the state to go to Virginia.
Correct. Around the time that the news broke, but before he's been arrested or arraigned, he left and went to the state of Virginia.
Okay, so when you say the news broke, when it became public,
I don't
Or
know exactly
news.
when they reference, but I'm presuming sometime in the end of August, beginning of September, when everyone in the community, the church community,
Got
and the victims started coming forward and reporting to the police.
Okay, and so he left the state, some thinking that he's in Virginia, others thinking in Indiana, irrespective of that. For how long a period in time was the defendant not in the state?
I don't know the answer to that. They had just started to take the investigation and interview these victims. And when he was ultimately arrested, when the police arrested him after the conversation where he made admissions to one of the mothers about having these boys send him pictures of themselves masturbating, and he would pay money for them, when he made those admissions that are on tape that will be played at the preliminary exam, he was driving a rental car and had multiple electronics in the rental car that were seized. So that is our evidence, our indication that he is a flight risk. So
Well, and I'm sorry, but the rental, or he was arrested in the state of Michigan.
Correct.
All right.
In what?
In a rental vehicle.
Dundee. In a rental vehicle.
In Monroe County, down in Dundee.
Yes.
All right, go ahead. I'm sorry.
So that is just some of the information that the people believe that the court can consider and show that he is a flight risk. Beyond that, Your Honor, counsel talks about just because of the number of charges that the people bring doesn't affect bond, and I think it does. In this case, the allegations are, and the evidence will show, that the defendant abused his position of authority at the church. So it's not, we don't have one victim or two victims, we have multiple victims spanning over a year period of time. So he is a danger to the community, and the people's position is, if he were released, he would be contacting these victims, and there's nothing to stop him from contacting. Sure, there's a court order and we can violate his bond if he does it, but the appropriate thing in this case, and the multiple counts of criminal sexual conduct in the first degree, allow for this court to deny the bond. And that's what we're asking be done. The statute, the jury instruction on criminal sexual conduct in the first degree concludes that to prove this charge, it is not necessary that there be evidence other than that of the victim, if that testimony proves guilt beyond a reasonable doubt. So the victims of the criminal sexual conduct can come here and testify at preliminary exam. They can testify at trial, and the defendant can be convicted on it. There's not one victim of criminal sexual conduct in the first degree, but there are three. And so I don't believe it was an abuse of discretion to set the bond at $3 million. I do believe, based on the evidence in this case, that he is a danger to the community, and moreover, a danger to the victims in these cases. So I don't think it should be reduced. And we're asking that, pursuant to the statute and pursuant to the court rule, that it be denied.
Thank you. Response.
Yes, sir. So going back to the arraignment when he was actually given the $3 million bond, obviously the court didn't have access to what we've given the court, which is the doctor's report for one, you know, the letters of support and all these other things that are out there. Two, you know, there was no discovery that had even been conducted at that point. So whoever the attorney was that was arguing on behalf of my client at that time didn't have anything really to hang a hat on to make any kind of argument whatsoever at that time. But some of the things that the prosecutor just said in regard to this investigation in October, she doesn't know what the dates are when he was gone, when he came back. He came back to face the charges. He wasn't arrested somewhere else. He drove back here to face the charges. So he's not a flight risk. If he was a flight risk, he would have stayed where he was at. He obviously came back here to do the right thing, and that was to face the charges. And he cooperated with law enforcement. There is absolutely nothing that the officer in this case wrote in his report to say anything other than he was cooperative. If he was a flight risk, or If he didn't cooperate with at the time, that would have been written in the reports, and it's not. It's not written in the report anywhere that he was uncooperative or anything else. He absolutely came back and faced the music and got arrested, was even in the front seat of his vehicle, handcuffed in the front, from what I recall. Maybe he was in the back, I don't remember. But obviously he came back, to face the charges. So he is not a flight risk. And again, he doesn't have anywhere else to go. As I said to the court already, there are so many different things the court can impose. You can take his driver's license away, you can take electronics away, make no contact order. He is not a flight risk. He's not going anywhere. And again, going back through the answer to,
well, what was he doing in Virginia? And how long was he in Virginia? And did he end up in Indiana? And how long was he in Indiana?
You probably got to drive through Indiana to get to Virginia, I think.
No, being a Maryland Terrapin, you don't have to do that. In fact, you stay as far away from Indiana as you can.
I'm not from here.
So, So what was he doing in Virginia?
And he just reminded me what he went down there because I think that he had friends that were in Virginia, and he went down there to visit a friend, and he came back. So it's like a vacation that he was on, which is allowable, Judge. I mean, if you're not under,
I'm not saying it's not allowable, but counsel, you're leading this court to believe, and I'm not saying it may just be semantics, but you're saying to me he's only resided in the state of Michigan. I get the whole schooling thing, but that's not true. He resided in the state of Virginia. Then when all of this is at least brewing, from what I understand, and is out in the community, he then takes back off to Virginia and or Indiana for at least some, I don't.
From my understanding, it was only a week, Judge. Only a week. It wasn't even, I don't even think it was a week. Because he was back here, I think he was arrested on the 20th of October was the arrest date. And I think that it was only for a few days, maybe from the 15th of October to the 20th, something like that. Might have been a little longer, but I'm not sure what the dates were. But I know that he drove back on his own accord and came back. So there's nothing that anybody can say to the contrary to that. And, if he drove back here knowing that there was an investigation going on, if he was going to be a flight risk, then why would he drive back here? His intention was to go to Virginia and say, I'm not going to face the consequences. And why didn't he just stay there? He came back to face the charges. So, the flight risk thing doesn't work. And again, Judge, I'm not trying to play semantics on the court whatsoever.
No, I'm not saying that you were trying to play a game with it, but I'm just saying by interpretation, certainly of what you're telling me gives me a different picture. That may just be how we view the world. That's fine. But prosecutor does bring up a good point, and I don't know what your response to that would be, that at the time he's arraigned, there are a certain number of charges that are pending. The bond of $3 million is set based upon those charges. Additional charges are then filed. His bond remains the same. They don't ask at that point to up the bond. But as it sits before me right now with basically these competing motions, given the charges, and it kind of shifts in terms of one's burden, why wouldn't I grant the prosecutor's motion to deny bond unless I have before me something that is clear and convincing that he is not a flight risk and that he is not a danger to the community? Why wouldn't I?
And I would agree 100% with what you're saying, Your Honor, except for the fact that all the bullet points I've already presented, I don't want to beat a dead horse here, but again, if you look at the answer in her complaint, that she can neither admit or deny, for one, the meat and potatoes of my argument in 6, 7, and 8, she doesn't admit or deny any of those. So if you can't deny them outright, then your case must not be that strong if you can't deny it. She obviously doesn't have the proof.
Yeah, but that's not my standard, is it? Under the rule? I mean, the charges have been brought. And if I believe that there's a likelihood of conviction, then certainly I can go one way. But on the charges, certainly I could deny bond unless there is clear and convincing evidence that he does not pose a danger to the community and or flight risk.
Right.
And I'm getting, and counsel, and I'll just tell you, I mean, I sit here and I cannot certainly predict the future. That is not my job. But I certainly have to look at a person's behavior to try to assess what is the likelihood that that person will do it. And I'll be honest with you, I'm not getting really satisfactory answers to his whole Virginia connection, to where was he? And you're saying it's a vacation or whatever, but okay. And the contact with individuals and what he's saying to those individuals, knowing this is going to happen. I'm a bit hard pressed to say that that person doesn't pose a danger to the community in terms of what he will do. But I'm more than willing, I mean, I'll stay here as long as I have to. I'm more than willing to hear all of that. But those are things that go to those core issues of, does he pose a flight risk? I understand he has no criminal record, so I don't have that. But when all of this is going on, why does he take off to Virginia? And then these people, maybe this wrong, who are so close to him, they're not really sure where he is. Is he in Virginia? Is he in Indiana? Chief suitcases for 5 days? I don't know. But depends, I guess, on how you pack. But
With my wife before either.
pardon? Well, yeah. But that's a problem for the court.
Well, the only thing I can say, Your Honor, to this is this, if the guilt was evident and presumption was great in this case, we would have way more evidence to look at.
But counsel, here's the thing. As Mr. Reiser is pointing out, if one of these victims gets up and says, this happened to me, and lays out a series of events and a series of facts, then certainly he could be bound over to stand trial. And certainly a jury could convict solely on that. I mean,
you convict on circumstantial evidence. I don't disagree with you, Judge. Circumstantial, I can make an allegation against anybody.
correct. But then counsel, and I get that charges, the number of charges don't matter. But what the court also, in looking at that particular issue, does have to take into account is the people's rendition in their motion. There is this repetitive predatory behavior. Realistically, as our society is under circumstances that are really troublesome because of his position and these young adults. But it's not just one. I mean, there are just these numerous people, like victims, but an odd commonality to what they're saying. And maybe not so odd, but there's certainly a commonality as to what they're saying. That's anything else you want to say as to under the rule as to whether or not the court should strongly consider the people's request that I deny bond? Is there anything else you want to say?
Your Honor, I just think that, based on what I've already presented to the court, with the low risk coming from a doctor in your jurisdiction, that maybe he's even been in front of this court, I don't know. But I mean, obviously she put him as a low risk. I think that should weigh heavily on the court. I think that, his prior record, the fact that he doesn't use drugs or alcohol, that he has his entire family here, that he could get a job, that we're willing to let you take the electronics, no contact order. I think that,
if he got a job, counsel, what would he be doing?
he does music, Your Honor. I mean, he could,
Would he be around people, young people? Or people younger?
Not have to be around any young people, and the court could order him not to be around. That wouldn't be a problem. It's not any problem whatsoever. If you want to put him on house arrest, put him on a tether, he's willing to take that as well. You take his driver's license away and make him have to get driver's.
Counsel, I'm aware of what I should or could do.
I'm just saying that, Judge, there's ways that the court could obviously make sure that if he bonded out, that there's not going to be a threat to the community and he's not a flight risk. And I think that we've submitted many letters of people that have known him his entire life, friends and other people. I mean, he's got a whole courtroom of people on this side over here that are here to support him. And, and just the fact that he came back from Virginia and drove back here, which he didn't have to do. If he was going to be a flight risk, why would he do that? He's here. He did not try to stay gone. He came back saying, hey, I got to go back up there and I got to pay this fee. And he came back. And that should be the telltale right there, Judge. I think that, weighing these factors into place and going, okay, well, you might be a flight risk. Well, anybody can be a flight risk. Anybody. You could have a spitting on the sidewalk charge and be a flight risk. But I understand because of the type of charges that we're looking at, it's going to be scrutinized much harshly. And again, I think that we presented enough to this court, and getting a doctor to come in and see him in the jail and going through all these different things that we did. And again, this is my first try at a bond with this court. I didn't represent him at the arraignment. This is the first time it's been addressed in almost 105 days. So, this is our first shot at, asking this court to reconsider a $3 million bond. This family doesn't have $3 million to post a cash bond on this type of case, Judge. And, again, it's tantamount to no bond. So, and it's not
which can be appropriate in cases like this. You keep saying that, counsel. But I mean,
if the evidence is great and the presumption is great, if the guilt is evident, then yes. But again, Judge, you've even said that it's a circumstantial case at this point.
I haven't said that.
Well, I'm saying this.
I did not say that.
I know. I didn't mean to say. I'm saying that it's a circumstantial case at this point. And so, if the evidence was overwhelming at this point, where we had all this stuff that was just coming at us left and right, obviously, I would be in a very different position. If I didn't think I, had to hang up here, I wouldn't be doing this right now. But I've looked through all the evidence. I've seen what they have. And I mean, obviously, my client's innocent until proven guilty in this case, and he has a right to go to trial if he wants to go to trial. And obviously, he has a right to go through the preliminary examination, and we're going to hear from witnesses. But again, putting a $3 million bond on a case where there's not any CSAM and there's 33 counts, that involves CSAM. or, a lot of them anyway, not all of them, but, it's just one of those things that, I think the court should consider that, a reasonable bond in this case, which is guaranteed by our Constitution and the Supreme Court the Court of Appeals of Michigan, the site that I cited to the court earlier, guarantees you a reasonable bond. And if the guilt is not evident and the presumption is not great, then you have to move on to the next prongs, which is whether he's a flight risk or danger to the community. And then even if the court deems that doesn't mean no bond. Obviously you could put a higher bond on him, but again, an unreasonable bond for a guy that's indigent at this point. He doesn't have his truck got repossessed. He doesn't have a home. He doesn't have anywhere to go. All this stuff is gone to four winds. He doesn't have a phone or anything else. He doesn't have a computer. He doesn't have anything. So he's indigent at this point. His support's coming from outside influences, outside people or whatnot. So he doesn't have two nickels to rub together. So at this point, Judge, what I'm saying is that I think the court should look at all those factors that, it takes to be a flight risk. You got to have money. You got to, people don't pick up hitchhikers anymore. It doesn't work that way. I'm asking the court to consider it. I think that our request for a lower bond is reasonable based on the circumstances.
Anything additional from the people?
I do, Your Honor, I do. It is not disputed that after these allegations started to surface, but before the defendant was arrested, that he left and went to Virginia. Whether he went there for vacation or to dispose of evidence, he left the state of Michigan. When the defendant was arraigned and charged, additional victims came forward. And I am going to provide the court with an offer of proof of what one of those victims will testify to. And at the conclusion of that, I will ask that his bond be denied.
Go ahead.
The victim was jealous of Zach because Zach was a cool guy of the church. Everybody talked to Zach, and he seemed like he was a safe space for people. The victim got an iPad Touch for Christmas when he was 14 years old, and he got Snapchat in February of 2015. His parents did not want him to be on social media, but he defied them and got a Snapchat account anyways. The victim's handle on Snapchat was this. Zach, the defendant, added the victim on Snapchat, and they talked on Snapchat. Around June 2015, the defendant asked the victim on Snapchat if he had abs, and he asked for a photo of the victim shirtless. The victim sent the photo, and Zach told him to delete the photo from his phone. The victim did this. A few days before the first incident, the defendant asked the victim on Snapchat if he knew what a blowjob was. At that time, the victim kind of knew what it was. The defendant asked the victim if he would ever want one. The defendant offered to go on a drive with the victim and they could listen to music and talk. They hung out alone only on 2 occasions. The first incident was a Saturday night in July of 2015. The victim was 14 years old. He remembers this day because he went to church the next morning. On Snapchat, the defendant asked the victim if he had ever gone out late at night. The victim was bored and wanted to go out. In the middle of the night, the defendant drove to the victim's house. The defendant was driving a smaller sedan. The victim snuck out of the house and he got in the defendant's car. The defendant was in the driver's seat and the victim was in the front passenger seat. The victim remembers where they drove on Calder Court and parked on a street south of Harper Drive, so they were still near the victim's house. The victim was wearing loose shorts and he was a virgin. The defendant put his right hand on the victim's left thigh and began to rub it up and down his leg. The defendant asked the victim about blowjobs. The defendant made it seem like blowjobs were a thing that he did with his friends. He called them bro jobs. The defendant chucked the victim's penis over his short and with his right hand. The defendant used his right hand to pull down the victim's shorts and underwear to his feet. The victim said he froze out of shock because he didn't know what to do. After the defendant pulled his underwear and shorts down, the defendant touched his exposed penis with his right hand. The defendant leaned to his right and put the victim's penis in his mouth in a sucking manner. He sucked on the victim's penis for 3 to 4 minutes. He stopped sucking on the victim's penis when he ejaculated in Zach's mouth. The defendant asked if he was okay, and the victim said he did not know. The defendant asked if it felt good. The victim said he felt weird. The defendant told the victim he did not have to do it again, but he wanted to give him a space to feel good. The victim asked if he could go inside. And the defendant was okay with that. So the victim got out of the car and went back to his house. Said he could not sleep that night. The next morning he had to go to church and Zach was there. They did not talk about what happened the night before. His parents didn't know he snuck out. The victim said he was scared because Zach was a bigger guy. The second instance occurred in 2016 when the victim was 15 years old. They were still on Snapchat, and the defendant alluded to engaging in more sexual activity, but the messages did not use the word sex. The victim would confide in the defendant about getting in trouble with his parents, and the defendant picked him up in the middle of the night. He instantly came down to get the victim. In the same sedan as the incident before, the defendant was in the driver's seat, the victim was in the passenger seat. They drove to Oakwood Church's building, currently the Washtenaw Christian Academy. They pulled into the parking lot. The defendant asked the victim if he'd ever given a blowjob. He said he did not. He kept pestering about giving a blowjob, and the victim was hesitant and told the defendant he felt weird. The defendant pulled his own pants down and said that the victim should suck his dick. And the victim said, I don't know if I want to. The victim froze again and the car was silent. A few seconds later, defendant started masturbating while the victim was sitting there. The defendant whispered to him, you should help. And the victim didn't move. The defendant put his right arm around the victim's shoulder and neck. The defendant pulled the victim toward his lap, and he felt like he did not have a choice. The victim sucked the defendant's penis for about 2 minutes. The defendant had his right hand on the back of his neck, and if he tried to sit up, the defendant pulled him back down. This ended when the defendant ejaculated in the victim's mouth. The victim turned to the right, opened the passenger door, and threw up. The defendant asked, why'd you do that? And the victim did not respond. The ride home was silent. He dropped the victim off. The victim did not sleep that night. He had nightmares. He was scared for his life because he thought Zach had a gun. Before this, he said Zach always had a gun on him, but he did not see a gun on this night. His parents didn't know about it. They forced him to go to church. He would see the defendant at church every time. The defendant would tell the victim they shared a cute little secret. In a span of a few months after the second incident, the defendant texted the victim to see if he wanted to meet up, but the victim declined each time. Then the defendant started to ask him for videos of him masturbating. He didn't send any. The defendant in June of 2015 asked the victim if he could ever send a nude photo before. The defendant offered to send the victim a photo of him. The defendant said he would pay him $20 for the photo, so the victim sent the defendant a photo of his penis on Snapchat. The defendant gave him $20 cash for the photo the same night of the July 2015 incident. During the trooper's interview of the victim, he teared up, his body shook, and he took a deep breath in long pauses. He said these events were hard to talk about. We're asking that the bond be denied. That's one victim's testimony that I anticipate you will hear at this preliminary exam.
Of course, we're going to take a brief recess, read over the documents, the letters that you sent, make sure I have that, take a look at it. I will come back and give you 14 minutes. We're back on the record in the case of the People's State of Michigan versus Zachary Radcliffe. In this case, there are, in essence, competing motions regarding the defendant's bond. The defendant is asking that his bond be reduced, and the people are asking to the contrary that his bond be effective, well, not effectively, but denied in this case. The court rule is very clear and very specific in terms of when the court can deny bond to an individual. There's a statutory section which applies to it, as well as a court rule. Specifically with reference to the court rule, the court may deny bond to a defendant that is charged with criminal sexual conduct in the first degree, armed robbery, kidnapping with the intent to extort money or other valuable thing. Thereby, if the court finds proof of the defendant's guilt is evident or the presumption great, unless the court finds by clear and convincing evidence that the defendant is not likely to flee or present a danger to any other person, or what one may say, a danger to the community. The court can take a number of factors into account, and I've given, I think, each side an opportunity to respond to the court's inquiry as to what was going to be important in terms of the court's deliberation. People have done, well, both parties have done an excellent job in laying the issues that the court needs to decide before the court. I would say that the people's rendition of the statements and stories, at least the minimal synopsis of the statements and stories of the alleged victims in the case, are indeed compelling to the court. And one of the first inquiries that the court had was, as the court sees the whole thing, what really is a grooming and predatory behavior as you see each of these incidents. The court does take into account also that the defendant's position within the church and access to the youth play a factor in that, as it does in cases where there are children involved and certain behaviors, threats, if you will, enticements, other things can come into play. What is also of note, and something that the prosecutor brought up, and I think does bear noting, is that the defendant's bond initially, when the initial charges were filed and the arraignment was set at the $3 million, the current bond that it is set at, did not take into account the additional charges that came forth. So this is really, in essence, the first addressing a bond with the additional charges of the additional individuals. I say that because I want to make it very clear that any change by this court is not based upon it's based upon the motion, not based upon any abuse of discretion by the magistrate in terms of initially setting the $3 million bond. But the rules, in essence, well, defense counsel is correct in pointing out that one looks at an individual's release and their ability to have bond or to be in a position to post bond and not restrict their liberty, except under those limited circumstances. And then it is almost as if and it is up to the people at that point to show that the defendant should be incarcerated. In limited circumstances, that in some ways shifts the burden in looking at certain things shifts. For example, in a crime of treason, violent felony where the other predicates are met, and then in certain types of cases where there is an analysis of whether guilt is evident or where the presumption is great. Given what this court has heard and the motions that have been filed and the information that has been put before the court does find that there is a great presumption that the people have established a great presumption of the defendant's guilt in this case. I would also indicate that the court is taking into account that the behavior is indicated, at least is laid out here. And I don't know what would happen during the course of testimony, but what has been laid out shows, I don't only want to say classic predatory behavior, but it in a lot of ways is, where individuals are basically these victims are placed into that position. Certain threats, either said or unsaid, are then placed upon these individuals, and then these individuals don't come forth. As the proffer indicated, that was put forth by the people. If that's true, and if the evidence, I should say, bears that out, one can see what the court is talking about with reference to an individual that is a young person who is forced to engage in sexual acts, who is then that next day has to see that person in, well, places, a church, and that person being in a position of power or authority. Been doing this a long time. That whole concept may seem like it's just something that just happened. Frankly, when one looks at it on the surface, that it's actually, if this is a circumstance where the two incidents, that's all that I had necessarily before me, occurred, that's not by accident. That is, that whole series of things is by design for a very good reason, because that stops this person from saying anything, doesn't say anything to the parents, doesn't say anything to the people in church, doesn't say anything because of where this happens. And the longer that goes, it becomes more difficult for the person to say so. In just listening to that, looking at what's been laid out by the people, the court, as indicated, does find that there is a great presumption of the defendant's guilt. It then shifts to show by a higher standard than normally would be applicable in a bond argument of basically a preponderance of evidence, but it shifts to a clear, convincing standard to show that the defendant is not likely to flee or does not present any danger. And that really does shift in essence, to the defendant to show that, or at least put forth some evidence to the court where the court could conclude that. This court does not conclude by any stretch of the imagination that the defendant is not likely to flee. The court believes that the defendant is in a position of potentially facing life sentences. That also there is a circumstance, and it's a bit unclear, a bit murky, but where he knows that he is subject to at least an investigation and flees, or at least leaves the state. Oddly, where the parents or those that most likely would know where they are, where he is, don't know. And he is there. Counsel may make a good point that when the very fact that if he were going to flee, that he comes back, under what circumstances and for whatever his reasons are of coming back, I don't know, and maybe that's to be told, but this court views that as something where clearly the defendant has connections in other states that he could flee to. I think that the laying out of the number of victims, not necessarily the numbers, but the number of the acts, make it more likely to this court that the defendant would flee or could flee to that. And the court does believe that he poses a flight risk. I also do believe, because I think it becomes a bit difficult when one is trying to address, does this person pose a danger to another person and or to the community? This court does believe that this defendant, given all of the circumstances that the court now has before it, does pose a danger to the community. I've read all of the letters of support that the defendant does have, and people have good things to say about him. They have good things to say about his family. I make note of one thing that the prosecutor said, and it doesn't seem like it's much, but for this court, it was much, where in talking with Michigan State Police, she either blurts out or says that her son is leading a double life or a separate life. I don't blame her for saying that. I think it may have just been something that she said when she sees everything. And I think that that's true in this case. And so I also think that there isn't, given the magnitude of what the defendant is accused of in this case, that while the court has many tools at its disposal, the court doesn't have the, I don't think, proper tools that would be able to monitor and prevent the defendant from hurting other individuals or engaging in this behavior with other individuals. The only way the court would have to do anything along those lines is certainly to order that, but that doesn't mean that the defendant has to follow it. And then we don't know until somebody else's mental health and or physical health is damaged that it has occurred. And this court is not going to take that risk given the circumstances and what the court is looking at. Taking all of that into account and looking at everything, and now looking at this case with the number of charges, the number of alleged victims, the court does not believe that the $3 million bond, which was initially set, is an appropriate bond, and that under the circumstances, the court now has heard them and now knows the defendant's bond ought and should be denied. And so therefore, I will deny the defendant's motion to reduce bond. I will grant the people's motion to deny bond. Defendant's bond is denied. We are also set, go ahead.
Thank you.
We are also set for PCC. are we ready to proceed to the next stage in this matter? Or we're up?
Judge, I was gonna ask the court, will you give me will you do a written motion on that order that you just made?
You mean a written order?
Yes, sir.
I usually do not prepare a written order. If you'd like to prepare one, you may, and I look at it and sign it. But I mean, in terms of, there'll be a written order denying his bond. But
No, I understand. I just wanted your written findings in the order that you put on the record.
I'm gonna let the record stand. If you want to draft an order, counsel, I will be more than happy to look at it and sign an order if it's appropriate.
Okay. So as far as the PCC goes, again, we just got their supplement report yesterday, number 12, where the last one we were here on the 9th, that I had asked the prosecutor specifically if there were any more warrants out. There was not. Apparently there are. There's Snapchat warrant number 1 and 2. Based on that report that I just got yesterday, there's Beth's phone. I don't know what that is. And she's got also on there that the MacBook Pro, the black MacBook, and another phone. Apparently they're still doing some forensic stuff on that. I'm also going to address some of the older stuff that we previously asked for, which she alluded to today, I think, which was the wired conversation between
what conversation?
Wired. I've looked through my stuff. She can direct me to a time or date stamp or in a date for that particular conversation that was made between Priscilla and Mr. Radcliffe. I've looked through all my stuff.
First name Priscilla being
Berg.
All right, go ahead. Oh, I got you. The X in him.
Yep. So there's apparently a conversation that was recorded that I don't have. I don't know if it's something that they've sent and it's in something else possibly, but I pretty much have gone through everything that has been sent and I have not seen that. And then we've also asked for the victim advocates notes, which were done by Megan Calamita. Whether they're exculpatory or inculpatory, doesn't matter. We're entitled to them. And we have a right to those notes. If any of the victims made statements to the victim advocate, I would ask for those notes. And I previously asked for that information.
So what I have here is I have two things: the wired communication and victims advocates notes. This one here.
Those two things, but also, Your Honor, are we going to get Snapchat warrants? That I thought warrants were no longer in play, but again, we just got the sub report 12 yesterday, which says that these are outstanding. The Snapchat warrant 1 and 2. So I didn't think that there was any more warrants out there for material. If they are, that's fine. I just, I thought that we had already answered those questions.
Mr. Adams.
We would ask that a preliminary exam date be set. I believe that we'll need a separate date because of the number of witnesses and the length of time that it will take. So I would request that it not be set on a Tuesday with other exams because of the number of victims that are set that will be testifying, I should say. The recording should have been sent, and I'll confirm with our discovery clerk if it went evidence.com or if it's something that counsel needs to pick up, but it is item 22, the recorded conversation between the defendant and one of the witnesses. So he should have that, and I'll double check. And the
so you believe what's been referred to as the wired communication has been sent?
It should be. I don't know if it went on evidence.com. It's listed as item 22, so I have to check with Ms. Warnick because she sends everything out. I don't know if it was mailed on a DVD, but that should have already been
gone to. Okay.
That's it. I don't believe, I don't have, and I don't believe that the victim advocate's notes are discoverable. So I would ask for some authority on that. I don't know how they would be relevant.
I don't know how they would be discoverable either. Do you have anything on that?
I don't have. I think I may have something, Your Honor, that I can forward. I can file something as a supplement.
That's fine. I mean, on first blush, I almost look at it as though it would be getting an attorney's office personnel notes regarding conversations that they have with clients. And it would seem to me on first blush, I'll give you an opportunity to get something to me, that's going to be privileged information and that wouldn't be released. So subject to getting anything else, that's going to be my ruling, that those notes that with regard to victims from the victims advocates would be privileged communications because of their contact with the prosecutor's office and their work product, which may be part of the prosecutor's office. So that's the theory that I'm operating, but certainly counsel, feel free to file whatever is necessary. I was a bit confusing at the last hearing because I wasn't sure what warrants we were talking about. But I guess counsel has just received another report.
Supplement 12 is not a warrant. Supplement 12 is an interview with a witness about a conversation. Supplement 12, January 13th, 2025. A witness called to talk about disturbing comments that the defense father made. That's supplement 12. It has a journal, but it's barely a page long.
Hold on,
The report was sent over to her.
Hold it, because I want to make sure we're talking about the same thing. Because when I listened to Mr. Thomas, it sounds to me like you were saying there was a warrant out. Information came back from that warrant. Created a report.
Forensic analysis of the defendant's devices. I don't know the time limit on that. If we don't have passcodes, we could.
No, I get that, but I want to make sure, folks, that in regard to number 12, that we're talking about the same thing. Because as I understand what Mr. Thomas is saying, and correct me if I'm wrong, Mr. Thomas, it seems to me he's saying that there was a warrant that was out, that warrant netted certain information that then was placed into some supplemental report, which was just produced.
Right. I think it's at the end of 12. I looked at it briefly. I know it said something about the Snapchat warrants were out. It's I think toward the end.
So the supplement 12 is maybe 2 paragraphs. It's a witness that called to talk about some disturbing comments that the defendant's father made at 125. Status open, the case is open, pending the CCU's forensic analysis of the defendant's devices. There is something they're trying to pull off Beth's phone and search warrants for Snapchat 1 and 2. So those are outstanding things that the police department is waiting on, if you will.
Got it. Okay, so that's how I get to the Snapchat. The best. Okay. Now I think I understand.
The search warrants have been served, and we're waiting on the return.
Waiting on the returns. Got it. Okay. Now I think I understand. So there was a report generated. At the end of that report, it just lists what else is out there that everybody's waiting on.
Correct.
And that's where the snap. Okay. Now I see where we are. So do we have any indication of when that might happen? I thought that's what you were going to say. Okay. So with that, counsel, I mean, I can set a preliminary exam date and what comes through, and I'll entertain whatever comes at that moment, but I don't know what's gonna, I mean, I have no idea what's gonna come of that. But what's your preference in terms of?
I mean, I'm fine, Judge. I think that, what I don't want is to get hit at the last second with a piece of evidence that we didn't get a chance to look at or to scrutinize, or, obviously you would understand that. You work on a strategy and, and then all of a sudden somebody produces something.
No, I got you. And I guess what I can do is I can set a prelim date. I can then indicate that if something is there, then certainly I would allow you to make that argument where it would cause a problem for you, and I'll deal with it how I have to deal with it. But I think at this point we have to move this case along. So I'd like to do that. With the understanding that the other forensic, the electronic, the devices may not be available at the time of.
I mean, as your honor knows, these devices, it could take 2 years for the computer crime lab to get into them. So we can't adjourn, but we could be adjourned for another year, another 2 years. I just
not doing it.
Don't have the time.
I would just ask the court if, if it's not produced and they get it at the last minute, either we're going to get continuance or not.
Right. I mean, well, counsel, just so that you understand how I work, I'm not going to let anybody. I expect counsel to do their due diligence in terms of any evidence that comes for us. So I don't expect somebody to lay out a piece of evidence. I haven't had an opportunity to do that. But I would not, I think counsel should be very clear. My expectation is that whatever information has to be given to each side will be given in ample enough time where the other side can do what they need to do. If they don't, if you run into that situation, I will always hear one's argument about why I can't proceed if something has just come to you. You haven't had a full-blown opportunity to do that. I'm not going to do anything that puts anybody at a disadvantage. So when would we like to do this?
Do you have certain days that apparently you do them on Tuesdays, right?
Well, yes, but that's rotating. But what Ms. Reiser indicates is that it's going to have to be a special day. So it's going to come off of my very skimpy docket I have to give.
Well, on Tuesday, there are several other.
Yeah, it's not going to be a Tuesday.
Judge, I don't know if you'll do this, but can we do it on a Friday? Is that a possibility for just asking only because.
No, I hear you. Okay, so just what my reluctance is I have housing dockets on Fridays, which are intense and very long. And when I put them over, that means the next following week is even longer. And are Mondays bad for you? Or
just like any other lawyer, I mean, that's, I'm gonna have to make sure that I get everything cleared off my docket, on a Monday. I'm not overly worried about it, Judge, but
okay. Mondays work better for the court. I can tell you that. Ms. Reiser, what about Mondays regarding you?
I could find a Monday.
All right. So if we work with Mondays, why is this at 11?
This is a trial. That was the Simpson.
You like the
Trials in the morning.
Do we have anything set?
that work at 24th? Think of something else.
We really shouldn't, but Just- That's, yeah, okay. So I have available Mondays. I have February 24th, March 3rd, or the 10th, and whatever day I'll just clear out whatever else I have.
I am available February 24th.
The 24th.
That work for you? Okay. Preliminary examination in person will be set February 24th, 2025, 9 a.m., and that is before me.